morning, everyone. Welcome to our second day of oral argument here in the Harrisburg courtroom of the Supreme Court of Pennsylvania at our majestic state capitol building. As architect Alfred Houston envisioned this building to be a palace of art, I highly encourage everyone in attendance to visit the rotunda, legislative chambers, and governor's reception room when you have an opportunity, with an eye toward the beautifully crafted artwork, particularly the famous Violet Oakley murals installed in 1927. When you look around this courtroom, you'll see that we are surrounded by the Violet Oakley murals. She was the first female artist to ever receive a major public art commission, and her murals on the evolution of law are simply spectacular. Houston intentionally placed this courtroom on the fourth floor of the building, with the legislative and executive chambers on the second, both to physically separate and symbolically indicate that the judiciary is an equal branch of government. The majesty of this courtroom is designed to remind us all of the seriousness and importance of the work we are all here to do. Counsel, before we hear the first case, let me remind you of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent, and by introducing your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please do not interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we want to explore further. I also remind you that we do not allow rebuttal. While there's no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I ask that you conclude your argument. Mr. Minner, please call the first case.
In the interest of T.Q.B, representing T.Q.B, Mr. Spencer Bradley, representing the Commonwealth, Mr. Ryan Licen.
In this case, appellant, a juvenile, was adjudicated delinquent of the crime of transmission of a sexually explicit image by a minor after appellant posted on her Instagram account a video of the victim, an intellectually disabled juvenile, lifting her shirt to reveal her stomach, bra, and a portion of the bottom of her breasts. We granted review to consider whether these images constituted nudity as defined in the relevant statute. Good morning.
Good morning. Madam Chief Justice, members of the court, Attorney Ryan Licen. My name is Spencer Bradley, and I represent T.Q.B on behalf of the Dauphin County Public Defender's Office. The trial court and the Superior Court erred by construing and misinterpreting Section 6321G by reading the definition of nudity purely anatomically. The court below ignored the statute's latent ambiguity within its application, and in doing so, expanded the definition of nudity beyond both the language of the statute and the legislature's intent. It is in this applying the standard as announced by the Superior Court that we see the ambiguity of it brought to bear. This interpretation of the statute has massive implications for not only this particular statute and its different subsections, which include these sections that are not necessarily relevant to T.Q.B's adjudication, but as well as the understanding of nudity as defined in other sections of the Crimes Code. This court should reverse the Superior Court and vacate this particular charge of T.Q.B's adjudication. I welcome the court's questions.
Counsel, let me ask you, why would we have any interest in looking at other statutes when, in this case, the legislature did actually give a clear and unambiguous definition? They said nudity is any portion thereof below the top of the nipple. How can we possibly construe that as ambiguous?
Well, thank you, Justice Wacht. The ambiguity found within the statute, as I said, is within the is a latent ambiguity, but it's in the application and breaking down each particular word throughout the statute as we go through it. So the showing of the female breast, non-ambiguous, not a problem, not a question. With a less than fully opaque covering, got that. Any portion thereof is where the ambiguity starts. Thereof below the top of the nipple could refer to the top of the nipple, so referring to that as being shown and anything below that with it being shown, or, as the Superior Court read it, solely any form of anatomical relationship related to the nipple. I would submit, Your Honor, that that constitutes an ambiguous interpretation that requires the rules of statutory construction, which can allow for the consideration of other states and their definitions, but it is not necessarily a requirement to, interpret the state. It is used more within the context of showing how states, Pennsylvania being one of them, choose to criminalize this particular area. It's more of a comparative.
We don't get to choose. If the legislature tells us any portion of the breast below the top of the nipple, we don't get to choose whether to apply that language or not. That's what we're told the statute means. And just to make sure, you're telling this court that you don't know what that means. Is that what you're telling this court?
I am saying that that language can be reasonably construed to two separate meanings, which would constitute an ambiguity, which would require utilizing the tools of statutory construction. And to follow up on that point, it's ambiguous in the application. In this particular case, as recited, we're dealing with purely the underbreast of a juvenile. There's no nipple being shown. It is purely the lower exposed breast. Now, often that is viewed as the underboob, and it's more towards the arm, this area of the body. However, taking with it the Superior Court's interpretation of any area below the portion, that also cuts both ways. It cuts towards the median, which in an instance where, for example, you're dealing with something like a low-cut prom dress or something like that, that now constitutes nudity under the statute, which, if applied consistently, not only would subsection C, which we're at issue with today, it would also apply to A and B, which state sexually explicit images, but within the definition of sexually explicit also brings the definition of nudity. The statute is ambiguous in its application, particularity, and its understood phrasing. And part of this is to avoid a constitutional problem within the statute if it is construed as banning all forms of nudity, period. This court is well aware that nudity per se is not prohibited, even within the context of what would plainly be criminalized as child pornography. Simple nude images of a minor, as the case in Davidson pointed out, does not necessarily rise to the level of prescribed nudity.
Can I ask you kind of a follow-up question?
Sure, Your Honor.
You've said now a couple times ambiguous in its application, which seems to be a curious phrasing. I wonder if by that you're referring to the inevitability that DAs are going to use their prosecutorial discretion in circumstances like this, and to the extent that's the case, what's problematic about that? DAs exercise prosecutorial discretion all the time, and presumably the DA looked at these circumstances and felt this merited a delinquency petition, whereas in many of the nudity circumstances you recite, here and in your brief, no such exercise of discretion is used. What's wrong with that?
So if I understand your question correctly, Justice Webb, it is asking whenever I speak about ambiguities, how that would impact the exercise of prosecutorial discretion, or am I misunderstanding your question, Your Honor?
Well, let me break it down. What do you mean when you say to us, I think we understand what it means to say a statute is ambiguous, and that was the purpose of my first question, because I don't see any ambiguity in what they said here. Then you've been saying this, you've been reciting this term, this phrasing, ambiguous in its application. And searching my mind, all I can think of is that you're talking about prosecutorial discretion, which is a accepted and necessary device in our justice system. So what is it you mean by ambiguous in its application?
Thank you, Your Honor. That clarifies things. Whenever I say ambiguous in its application or a latent ambiguity, I'm using those synonymously. And by that, I mean whenever we're applying the statute to a female body, what would then constitute any area below the portion of the nipple when it's prescribed as underboob. That is what I mean by that. Our contention is the statute's language of any portion thereof below the bottom of the nipple. That phrasing, that clause, is ambiguous in the sense that it can either give full effect to the nipple, or it is using and requires the nipple to constitute nudity, or it does not, and it's purely an anatomical definition. Depending on how that is read, there's either criminal conduct that's prescribed along with it, or there's not. So while I would submit that we're dealing with we're trying to define a state of being and what that state of being is in terms of nudity.
Counsel, I just don't see the ambiguity. I mean, the way you're reading this, we would have to exclude the words. We would have to read this to say, the showing of the female breast with less than a fully opaque covering of the nipple. I mean, we would have to read out the entire middle phrase in this statutory language. I mean, I can't disagree with you. I mean, if what you're arguing is this is an odd definition of nudity, but it is what it is.
I would submit, Justice Donahue, that we wouldn't be reading out the any portion language as the hypothetical you provided provides for, in that below the top of the nipple, any portion, once there's the exposure of the top of the nipple downward, that would constitute nudity. That would be the whole encompassing act. It's dealing with the nipple as a predicate towards nudity, not necessarily the defining point of conduct. And I would analogize that to this court's decision in McCoy, where we're dealing with a definition of firing into a building. Well, if we're firing a firearm into a building, even if we're inside of the building, that language at its first blush is unambiguous, but in its sort of going to the application of it whenever it's actually being, exercised, the definition shows a difficulty in what is actually being prescribed, what the prohibited conduct is, what is not allowed to be transmitted by, in this case, minors. With the definition that seems to be adopted by the Superior Court, if the text is unambiguous, anything from extremely low cleavage to the underbreast is now prescribed and fair game for, criminalization. And I think part of this boils down, Your Honors, to the language of thereof and what thereof would actually be referring to, whether we're dealing with it referring back towards the female breast or whenever one does consult the dictionary definition of thereof, of it is an alternative definition. The of it in this case we would maintain would be the below the top of the nipple.
Well, I don't understand that. I'm looking at the statute, and the word thereof appears before any mention of nipple. So the only thing that thereof could be modifying would be the female breast. Is there some other thing it could be modifying in that sentence?
I would generally concede that it is referring back to the female breast. However, I don't think there is any contradiction between the requirement that any portion below the top of the nipple is, perhaps I misspoke earlier, but the struggling or the ambiguity that I'm seeing here is, what does the phrase the top of the nipple mean whenever we're attempting to affix a definition of nudity? If the top of the nipple is simply point to it at the body, wherever it is, anything below that, if it's exposed, is nudity, that's, it doesn't necessarily require the showing of that nipple because it's a portion of the body below. Or is it the top of the nipple and anything down with it that is prescribed? That, I would submit, is whenever I'm talking about whether there's an ambiguity within the statute, that's the ambiguity. That's where it triggers the requirements of using the canons of statutory construction.
All right, are there any other questions for Mr. Bradley? Thank you, sir. We'll hear from your opposing counsel, Mr. Licen.
I apologize again, Your Honors, about the whole sickness situation.
We understand completely.
Stand back. May it please the Court, Your Honors.
And please raise the mic because you're pretty tall.
I know they don't let me touch this a lot.
I know you do have an opaque, fully opaque covering.
I'm glad my shirt is opaque because I don't have an undershirt today. May it please the Court, Your Honors, Ryan Licen here on behalf of the Commonwealth of Pennsylvania, appellee in this matter. I just would substantially rest on the briefs of amicus as well as mine, in as much as I agree with Your Honors that we don't see the ambiguity just in where the words come within the sentence. The word nipple has not been introduced into the definition until several words after any portion thereof, which I would think would relate back to female breast, not nipple. And I'm not trying to be Pope Pius IX here and say what are our societal mores of decency and stuff. Just definitionally, I think it's pretty clear here. And it is a little more, I know I'm on camera, sensational, I would say, the underboob or the side boob than cleavage. I mean, cleavage is fairly seen in this day and age. And when we do see the underboob displayed, it's a fashion statement or to get the attention of something, I would submit. And so the fact that the incompetent juvenile in this case had to be goaded into it, I don't know what other intent the juvenile in question would have in goading this individual to lift her shirt up.
Why does any of that matter? I mean, the statute is all we're not dealing with some mens rea question here or constitutionality. That's the statute. Doesn't the statute just end the case?
My argument is that it does, Your Honor. But I think that that is supported by the intentions that the drafters had and the way we read statutes protecting juveniles. That's the goal at the end of the day here, is so we have to read them a little differently than other statutes and have that consideration at the end of the day instead of the rule of lenity to protect the minor to the fullest extent that we can. And the fact that this went viral as well, it was streamed live and then it remained up so that others were able to, much like I am viral today, to see. It just goes to the sensational nature of that area. And so I think that it's clear.
That might go to why it was prosecuted, but it has nothing to do with whether or not the statute is clear and unambiguous.
Okay, I understand, Your Honors.
Yeah, in other words, it sounds like what this latter part of your argument seems to be doing is re-arguing a debate your office might have had with defense counsel at the charging point. We're past all that.
Okay. I apologize, Your Honors. I'm very sorry. And that would conclude, I guess, all the salient points that I have, if Your Honors.
Questions? All right, thank you both.
Thank you, Your Honors. And I apologize about all the kerfuffle. Thank you again for coming.
Take a moment to fumigate.
Yeah. My wife-
No offense.
Commonwealth of Pennsylvania versus Daniel Chisebwe, representing Aplt, Mr. Brian Ulmer, representing the Commonwealth, Mr. John Fagan.
Under sections 1311 and 1511 of Pennsylvania's Vehicle Code, a motorist must produce his or her registration card and driver's license upon demand by a police officer. Statutory exceptions to each of these requirements exist in circumstances where the motorist produces the required documents at the police station within 5 or 15 days. In this case, we must determine whether the evidence was sufficient to convict a motorist who was stopped for a traffic infraction for violating sections 1311 and 1511, where the motorist initially refused to produce his driver's license and registration card, but ultimately produced the documents 25 minutes later after the police threatened to remove him from his vehicle and take him to the police station. Good morning.
Good morning, Madam Chief Justice, Justices, Attorney Fagley. May it please the Court. My name is Brian Ulmer. I represent Daniel Chisebwe. The Chief Justice obviously accurately stated the circumstances. The real points of concern here should be this. Number one, the Superior Court has acknowledged in its decision that it essentially carved out its own exception and has, for all intents and purposes, legislated from the bench. In addition, unfortunately, the factual underpinnings for that decision are flawed. The Superior Court noted that it was precluding Mr. Chisebwe from being credited for the fact that he did produce his registration and his license at the scene because they deemed his behavior as belligerent and combative. The summary trial reflects no such thing. As the Court knows very candidly, my client made a request that was improper. He wanted to be Mirandized. He wanted to speak to a lawyer. He does not have those rights. He understands that now. There's nothing in the record that reflects that he was verbally abusive to Trooper Arbogast, that he cursed, that he swore, that he raised his voice. He may have been stubborn. He may have been obstinate, but there's a huge gap between combative and belligerent and having to be convinced of something.
Does the statute say anything about combative or belligerent?
It does not, from what I've seen.
So suppose you take a check that's payable on demand to a teller, and you present the check and demand payment on this demand note, and the teller says, "No, I don't know. I don't think so. I'm going to talk to my lawyer. I don't know." Argues with you for 20 or 25 minutes, very politely. No combativeness, no belligerence. Maybe you have to go get the issuer to come in. Maybe you have to go get a lawyer to come in. Like there were 4 or 5 troopers involved here. And then 20 or 25 minutes later, the teller finally pays you on the check. Were you paid on demand? Were you paid upon demand?
I would say yes, and I would say it may not have been on the initial demand, but ultimately it was on demand. And particularly in this case, the fact of the matter is, and the Commonwealth addresses this in its brief, and the brief is very comprehensive and very interesting, in noting that what the defense, what the appellant has relied upon is the delay, the fact that you can go in later and you can produce this. And the argument is, well, that was not done in this case. But we're dancing around a legal fiction. My client did ultimately produce the license and the registration at the scene. There would have been no reason for him to exercise those options.
Well, the reason is that this, again, we just had an argument on statutory language, so you can't argue that those exceptions apply here.
Your Honor, that's a fair point, but they wouldn't need to apply.
Well, okay, so we don't, you agree that the exceptions don't argue, and all we're really focusing on is whether your client produced on demand.
Well, that's part of it, but the concern is this. If we accept the Superior Court's language as it stands, and I believe we pointed out in this in the brief, it can lead to some absurd results.
Which language? The belligerent thing?
Yeah.
Well, I'm past the belligerent thing. I'm just trying to figure out how many state troopers have to be diverted to respond to get someone to produce a license and registration on demand before we consider it a refusal.
That's a fair question, and actually, it wouldn't have required that much. From what the defense understands of the law, Trooper Arbogast would have been within his rights to say at the time, okay, well, I've demanded it, you're not producing it, now we're taking it to the next step. He did not do that.
He doesn't need to explain. I mean, ignorance of the law is no excuse.
No, of course not.
If this is not demand, then what is demand?
Well, in this instance, when it was ultimately produced was after a demand, and yes, there were many demands, and the appellant will concede. And what's interesting, but the candor is due to the tribunal. We sort of latched on to the notion that my client was asked 20 times, because that was testified to. There is a reference that it could have been closer to 30. But the request is, sir, please produce your license, your proof of insurance, and your registration. It's a 5-second request. If it was asked 30 times, it's 150 seconds. We're talking about a matter of a few minutes.
Counsel, I'm not sure I get your argument. And, you know, we have a body of law, it's sort of separate law about the submitting to chemical testing, the implied consent law, maybe you're familiar with it. Anything less than an unequivocal acceptance or agreement to the request for chemical testing is considered as a matter of law a refusal. Why shouldn't we basically bring that principle forward and say, once a police officer demands that you produce anything less than an unequivocal production of the materials requested by the police officer is a refusal?
I think the legislature needs to tell us that. I think they absolutely can, but they did not in this case. And it was the Superior Court.
What more could they say than upon demand?
Frankly, they could set a specific time limit, and more to the point, they could define what is combative or belligerent to say that you've disqualified.
Well, again, you keep going back to the combative or belligerent thing. I think your argument is good on that, but it doesn't necessarily mean you win.
Fair enough.
So that's why I'm kind of moving you toward the point, looking purely at the language of the statute. How can you argue that when and maybe you do have to incorporate the exceptions now that you've said that the General Assembly could have said something. The General Assembly did, in the sense that they did give your client an out, notwithstanding his belligerentness, notwithstanding the 30-some requests, notwithstanding any of that. The General Assembly gave your client the out, which is he could have gone to the police officer headquarters and submitted it the next day or gone to the issuing authority. He had that out. What I see you trying to do is to create a third out, which is basically if after upon demand there is a refusal, so long as the police officers continue to make a request and so long as he is still on the site and hasn't been brought in yet and hasn't been cited, he can change course. But the General Assembly didn't provide that as an exception.
That's true, and one of the difficulties here is, frankly, determining when there is a true refusal. If you're like some of us, and I say us for a reason, and you keep less than a tidy car, yes, these documents certainly should be on your person or in your glove compartment. But if you're scrambling around looking, by what we've read here, at a certain point, an officer, a trooper, a deputy could say, no, you're done.
You're changing the facts, counsel. There's no evidence in the record that he couldn't find the insurance card or he couldn't find his license and registration or was having difficulty. I mean, if that was the case, I doubt they would have called for police backup. So I'm not sure why, though. Let's focus on the facts in this case and figure out from a statutory construction perspective whether your client produced on demand.
And I'm not trying to change the facts of the case. My intention was to draw that as a point of comparison. In this instance, candidly, because it doesn't say how many times it can be demanded, it was produced on scene. And I do see the difficulty in the facts. And obviously, when you hear multiple police were called in, when you hear that this was a 25 minutes stop, I can understand why that's disarming. But the fact of the matter is that ultimately my client did produce them at the scene. It may have required a number of demands, but he did produce them upon demand. And frankly, it's something that is a little vague in the statute. It doesn't say first demand.
It seems to me that your client did refuse to produce his license. He said, I want a lawyer. I want, bear with me at that. I mean, at that juncture, what's supposed to happen?
Well, at that juncture, and unfortunately, it is regrettable that...
But he refused.
What I would offer is that, in fact, he did not refuse. He did not say, I'm not going to turn this over. He said, I want to talk with somebody else.
You're better off if he refused. Because as I read the statute, if he refuses, it doesn't say he can't find it, I don't have it with me, it may be somewhere else. The statute doesn't call for any excuses for why you aren't producing on demand. As I read it, you could just refuse. And then you have 15 days to come up with the license and information at the police station or the other designated location. Or am I wrong?
Well, where I respectfully disagree is the fact that essentially he had to be convinced that he had to produce it. The scene wasn't initially a refusal. So I fall back on what I recall the record was not, I won't give this to you, but I want to talk to somebody first. He was wrong in doing that. So I don't think it's completely fair to call it a refusal, because he's not saying, I'm not doing this.
Frankly, I think if the police officer at the scene would have said he's refusing to produce, cite him. And then within 15 days, if he shows up at the police station or the other authorized location, the exception applies. Isn't that what the statute says?
That's what the statute says, but as indicated, because this is such an unusual situation, we have a production at the scene.
Because the troopers wouldn't take no for an answer. And that's okay. I mean, I'm not suggesting that they had to take no for an answer, but they wouldn't take no for an answer. He said, I want my Miranda rights. I want a lawyer. I mean, it's a refusal.
And
instead of citing him, which they could have, they called 5 other troopers to the scene over the course of 20 minutes.
I beg your pardon, sorry for interrupting. I understand the interpretation, but without the appellant saying, no, I won't do this, I would respectfully disagree that it wasn't a straight refusal.
Okay, I think we...
Can I ask one more?
Well, sure.
I can understand your argument, counsel. If you prevailed here, would the precedent establish that law enforcement officers would have to explain the Crimes Code provisions as they interpret them when an arrestee or a detainee inquires or questions whether the enforcement action is appropriate?
I don't believe it goes that far, Your Honor. I think if Mr. Chisebwe prevails here, what happens is that, number one, perhaps the legislature will be persuaded to draft a modification to the statutes that precludes folks that they deem as belligerent or combative. I think it's likely that future troopers, future officers simply say, I'm going to designate this as a refusal if you don't produce it. It's a matter of a few seconds of dialogue.
Yeah, you know, that's interesting, and Justice Donahue asked you this. You know, police officers nowadays are criticized constantly for being quick to cite, quick to do this, quick to do that. And here you had a police officer that had a refusal and tried to convince the guy to comply with the request, gave him numerous opportunities to comply with the request. And you want us to do a construction that basically says, as long as the police officer is continuing to be courteous, the driver can continue to refuse the request, and only upon penalty of being removed and taken for identification to a police department, then produces, everything's fine. I don't think we should be penalizing our police officers for trying to convince someone to be compliant.
Your Honor, let me say this, and I hope that this is reflected in my discussion both in the brief and in person. It is not my purpose to bury the police here today. I know Tyler Arbogast. He's a fine young man. He's a fine trooper. I disagree with how this case came out. We're not asking for the troopers, for the police to be damned in this. And you know, one of the points that counsel made in his brief was that perhaps the side of the road was not the place to debate the finer the points of the Bill of Rights. While I think it's always a good time to debate the finer points of the Bill of Rights, I understand that that location may not have been the best. I think what happens ultimately is it will be a case-by-case situation, as so many of these are. One of the issues that arose was safety, and certainly that should be a paramount concern. But there are times and places where you can be off the side of the road, there's barely anybody around. There can be places where it's very heavily trafficked. I think it'll be situational. I think that they'll have to determine, you know, as this goes on, how much time can we spend on it? How much time should we spend on it? But if the Superior Court's decision is left to stand, frankly, I think we put them in a bad spot as well, because then it turns into individual officers having to justify what they deem as combative, as belligerent.
Can I just
Go ahead.
Could you remind me what happened to convince your client to eventually produce the information?
They were coming in the car after him.
Okay.
That would be persuasive. Any other questions? Thank you, Mr. Ulmer. We'll hear from your opposing counsel, Mr. Fegley.
Morning, Madam Chief Justice, Attorney Ulmer. I'm John Fegley on behalf of the Commonwealth. The evidence here to be insufficient to support the convictions of 1511 and 1311. That statute would have to read, a driver must produce their license and registration at any time within 15 or 5 days after the request of the officer. That's just not what it reads. It reads upon demand, and if you fail to produce it upon demand, you come to the station or you come to the magistrate's office to produce it within a time period to avoid penalty. It does not allow for a driver to stand on the roadside, argue, haggle, needlessly prolong a stop that puts the trooper himself and passing motorists in danger. Police officers get struck by passing cars issuing tickets. It's sad, it's unfortunate. There are accidents caused. Too often when you're pulled over, there's not a good place to fully vacate the road. It blocks traffic. These are not interactions that the legislature intends to extend, and that's why they chose the term on demand or upon demand. Justice Wecht already took one of my highlights of uses of on demand, so I'll move on to my second one. Is if I use Netflix or Hulu, my on-demand streaming service, and I log in to play a video, and it makes me bring over 3 additional friends and wait 25 minutes for the video to play, I'm probably not going to continue paying for that service. That's not what we understand on-demand to mean. It means at the time of the request. It doesn't mean 20 minutes later when there's 3 officers and the supervising corporal comes with weapons drawn. It's been admitted it's persuasive. I would say it's even precedential authority at that point. I would produce my documents once all those officers are on scene.
Yeah, counsel, at some point, if the police officer asks for the information and it's not produced, isn't that a refusal?
Yes, they have refused.
So there was never a refusal here?
I believe the testimony bore out that originally he asked to speak with an attorney or call friends, and then there was ultimate testimony where the trooper said, I asked you at least 20 times, and you said no. So there was also a flat refusal.
Yeah, but I mean, if someone demands the information and it's not produced, isn't that a refusal?
Yes.
Well, period. I mean, forget about what was said. I mean, I'm just trying to grapple with the extent to which this situation blew up.
So I believe in this situation, if the officer is able to effectively identify who the driver is, so they can issue the citation and know where to send it and have the court paperwork go, they would have the option to issue the citation and end the stop and then charge them with the extra charges. If they can't identify the individual to say who's getting the citation, where the paperwork's going, they're stuck under the vehicle code to arrest them and take them to identify them, unfortunately.
And so in this situation, they couldn't otherwise identify him to just issue a citation.
I don't believe the record is clear on whether that was capable of not. In the absence of facts to say otherwise, that I would have to assume that's why they had to continue it, and that's why they chose ultimately to arrest him before he succumbed to providing the documents. But,
Do you have further arguments, sir?
I have no further argument. If you have any further questions, I'll entertain.
Okay, I do have a question. Can you be arrested for not producing the documents?
Yes, under 6304 of the Vehicle Code, the Pennsylvania State Police are authorized to make arrests for any violation of Title 75.
And then the exception kicks in if you go to the station in 5 days?
Well, it would kick in for Section 1511 and 1311. It wouldn't kick in for the other citations or other potential crimes in the Crimes Code to be charged with.
And what were they?
In this case, it was...
that he was charged with.
Here, he was charged with speeding and also failures who have financial responsibilities.
Okay, so he was arrested for that?
Yes.
Not for not producing the information?
He was ultimately cited for all of them. The 1511 and 1311 are the only questions this court granted certiorari.
But he wasn't arrested for failure to produce this information. He was arrested because of the predicate
Yes.
stop.
Yes.
Okay, thank you.
Any other questions for Mr. Fegley? All right, thank you both.
Pennsylvania Professional Liability Joint Underwriting Association versus the Governor and General Assembly of the Commonwealth. Representing the underwriters, Mr. Kevin McCune. Representing the General Assembly, Mr. Carl Myers. Representing the Governor, Mr. Sean Kirkpatrick.
In 1975, the General Assembly established the Pennsylvania Liability Joint Underwriting Association, the JUA, which offers medical professional liability insurance to healthcare providers and other entities which cannot obtain such insurance through ordinary methods at non-excessive rates. Pursuant to a petition for certification filed by the United States Court of Appeals for the Third Circuit, we are asked to determine whether the JUA is a public or private entity. Good morning.
Good morning, and thank you, Chief Justice Todd. My name is Kevin McEwen. I represent the JUA. And the context of the Third Circuit's question to this court is this state's attempts to take JUA's surplus based on the claim that JUA is an arm of the state and therefore the surplus is the state's money. The answer to the question hinges on whether the court applies the multi-factor test that the court has used in similar situations. Under that multi-factor test, our position is the JUA is clearly a private entity. The governor and the General Assembly, on the other hand, argue that there should be a simplistic test used, and that test should be simply whether the General Assembly created JUA by statute, and if it did, they argue JUA is a state creature and thus public, and so that the state can take JUA's funds. Now,
Mr. McKeon, can I just jump in here because I think you can help me on this. I know we took this question from the Third Circuit. I get it. I don't think we had to. We did. I'm having a problem with the question, which seems very generic. Is the JUA public and private under Pennsylvania law? I'm not sure we have any that we distinguish between public and private entities under Pennsylvania law. And it's curious to me that the issue in front of the Third Circuit and in front of the district courts are all about the federal constitutional and the takings aspects, and whether the JUA has some private constitutional rights that inure to non-governmental entities. Isn't that a federal question as to whether an entity like the JUA has federal constitutional rights? And if so, why should we be answering this question?
Your Honor, I agree with you that the question is phrased in a generic fashion. I think the reason, although this is just speculation, is that the question, the main question before the Third Circuit is for takings purposes, whether JUA's private property has been taken. And I surmise that the Third Circuit has asked this court the question, is JUA private or public, in order to facilitate its resolution of the issue of whether JUA has private property. But beyond that,
yeah, because I can sort of opine on whether it's a Commonwealth agency. I can opine on whether it's an arm of the Commonwealth. I can opine on whether it's a statutory facility. I can opine on whether it's an insurance risk pool. I can opine on a lot of things, but whether it's public or private doesn't really tell me anything under Pennsylvania law, does it?
well, it may, Your Honor. I mean, we cite the Greenfield case in our reply brief. It's the case in which Judge Rogers for the en banc Commonwealth Court in the 70s decided that PIGA was not subject to the Commonwealth Court's original jurisdiction because it wasn't a Commonwealth agency, and in doing that...
But see,
no, I understand.
I can tell you whether it's a Commonwealth agency.
And in our briefing, we've laid out the various contexts in which this issue has come up. They're ones that you're all familiar with: immunity, taxation.
But in any of those cases, have we used the phraseology public versus private?
Well, Judge Rogers in that case did use the phrase private. He assessed all the factors that we say are the factors in the test that should be used here, and he concluded that PIGA was private.
Or did he conclude that PIGA was not a Commonwealth agency?
Well, the holding of the case is that PIGA is not a Commonwealth agency, and therefore the Commonwealth Court doesn't have original jurisdiction. But
so is that how we should look at it then? Is that the question then? Is the JUA a Commonwealth agency? And if we say, Third Circuit, it's not a Commonwealth agency, that would be enough? Or do we actually have to use a binary choice, public, private?
Well, I think, Your Honor, that you will answer the Third Circuit's question in the way that this Court deems appropriate. But
well, and I would suggest that if the Third Circuit phrased its question in this manner, it had some reason for doing so, and we as a court will either answer it or we will respond that we cannot answer it as phrased. But it simply wants to know, it's not going into the nuances of public agency and all of the other nuances that our court has gone into over the years. It's asking a simple question, and so we can either answer it or we cannot. But in answering the question, I think we have to go into some of the inquiries that you've addressed and that you will address. And one is the JUA a creature of our state statutes? Yes.
Absolutely.
Okay.
Yeah.
And given that,
I would disagree only on this point, Your Honor, and that is my colleagues from the state are arguing this, I'll call it in quotes, state creature theory. And so the creature theory, briefly, is that the Commonwealth creates, or the legislature creates, all kinds of creatures. Then they give you citations. Every one of those citations is one that you would recognize as a standard political subdivision or a Commonwealth agency. They never get into the kind of situation that we have here with JUA.
Right. I understand. And if we get out of the creature language, we can just simply agree that JUA was created by a statutory action of our Commonwealth.
Exactly.
And then we could further, we could further agree, couldn't we, that as such it could be repealed
Yeah, took my question.
by the Commonwealth.
Yes,
The General Assembly
we
could
don't
repeal.
disagree that the General Assembly could repeal the statute that in which JUA has been enshrined or entrusted
Right.
with
And
this.
then it's gone.
Well, I don't know about that. I would say that when the statute is repealed, you would at least have the question, does there need to be dissolution of the association that was
Sure, there may be
created?
implementation.
And then I would further add that just dissolving the association doesn't mean that the Commonwealth gets the money, which
Oh,
is
no, no, no.
ultimately the
We're not
question
reaching-
here.
We're not reaching that question right now. I was just trying to explore whether this helps us answer the Third Circuit's question, is it a private or public entity?
But counsel, certainly your opposing counsel is arguing that it is defining. If this is indeed a governmental agency of such, or it is a statutory creature, then the monies that it holds are the property of the Commonwealth of Pennsylvania. I mean, that's ultimately why they're pursuing this, is it not?
Yeah, it is, Your Honor. I mean,
I'm
and
not suggesting that's correct because, I mean, in follow-up to Justice Brobson's question, can you have a statutory entity that holds private funds?
well, in the case of JUA, it absolutely is true. I mean, as a matter of fact, they've held private funds in their accounts separate and apart from the state with no state supervision other than what the insurance commissioner supervises all insurance companies for 40-plus years.
And we could answer the question as posed to us without offering any help at all to the Third Circuit in answering the ultimate question in this case.
It might be the shortest opinion we've ever given. Yes, it is. No, it's not. Go ahead, Justice.
Following the questioning of the Chief Justice, JUA is established by what, Section 731 of MCARE.
Yes.
Since it was established, what would preclude the General Assembly from amending that statute, requiring all its surplus to be paid to the general fund?
Your Honor, I would say that the major roadblock to that action is that in this context, you have to accept the state of play as of the time the conflict arose. And what we have here is JUA existing for 40-plus years. Everybody who dealt with JUA, including the insurance department in its actions, treated it as a private entity. The legislature decided in 2016 that JUA had a very attractive surplus that it wanted to take, and so it passed a statute saying, guess what? JUA is a Commonwealth instrumentality, and it's the state, so we can take its money. But that kind of, I'll call it subsequent legislative interpretation of prior legislative actions is something that this court has called oxymoronic, picking up on a Justice Scalia opinion, and it's not the way that you use subsequent statutes.
Well, Counsel, let me follow up with this. The board is, the governor, I apologize, the Commissioner of Insurance has the ability to appoint 4 members to the board, correct?
No longer, Your Honor, and as originally you're close. As originally formulated, there were 12 members on JUA's board. This was pursuant to a plan that JUA proposed to the commissioner in 6 weeks after the original cat fund statute was enacted. And it proposed 9 insurance company members and 3 public members. The 3 public members would be appointed by the insurance commissioner, but the board has always been dominated by private insurance company members of JUA. So, for example, this court's decision in the Penn State versus Derry Township case says, well, that answers the question. In fact, it's the first of the 5 factors we want this court to be looking at. The question is, who appoints the board? Who controls this entity? And in this situation, there is no doubt that JUA's board controls JUA, subject to the supervision of the insurance commissioner, that the insurance commissioner provides every single insurance company in the state.
Well, it's funded entirely by private premiums, right?
Yes, Your Honor, which is the 4th factor we want the court to look at.
So explain to me the relevance of that factor.
Well, in every case in which it's sort of a reflexive reaction, I think. When you go to take somebody's money, you find out first where that money came from, and did the person who wants to take it put it there in the first place or in some way fund it. And so in the cases we cite in our brief, Spear Drake, this involved the Philadelphia Facilities Management Corporation, which was the alter ego of the Philadelphia Gas Works and corporation set up. This court said there, they found very important factor to be all of the funds were derived from the city of Philadelphia, and so that was one of the things the court considered when it came to deciding that it was entitled to immunity. In the Snead case, which is the SPCA case, the court said, well, they get some funds from the state, but it's mostly funded from other sources. So we're going to consider that. We're going to put that on the private side of the ledger, and the court ultimately concluded. Here, there's never been a penny, not a penny, from the public fisc.
Does it make a difference that the clients that came upon which you've made your money were clients that were sent to you under the legislative statute?
Well, Your Honor, I don't think that it does. The state uses coercion in many, many, many instances to coerce private actors to do things that help the government.
That wasn't really the point of my question. I thought, and maybe I'm wrong, I thought that under the statute that you were created so that medical malpractice providers in the state who couldn't get insurance coverage from other private entities could go to the JUA, and you, by statute, was required to provide them with malpractice insurance to continue their business within the Commonwealth.
That is true, Your Honor. Yeah.
And that's when I was saying, basically, your client base came through the government statute.
Well, that statute, that is the CAT fund statute, required all physicians to have medical malpractice insurance for the first time in Pennsylvania. That statute also created the CAT fund, which was an executive agency in the Commonwealth. And that statute also created the possibility of an association. What the statute actually says, that I'm referring now to the CAT fund statute, what it says is the insurance commissioner shall, let me just get the exact words.
Well, and I'm glad you're bringing back, because that was one of my questions, I think in response to Justice Doherty's question about whether the JUA was created by statute. You said yes. The reality of it is, what you're getting to is the CAT Fund Act authorized the insurance commissioner to approve a joint underwriting association in lieu of creating an actual state-run sort of insurer of last resort.
That's exactly right, Justice.
Yeah, so there's no statute. The genesis of the JUA was not from the legislature, other than saying the insurance commissioner could approve a joint underwriting association.
That's right. And so what exactly what the statute says is the commissioner shall establish and implement, to your point, this is the insurance commissioner taking it all in-house. Okay.
Like the CAT fund.
Right, exactly, like the CAT fund, or approve and supervise. And so a plan, so the statute's key word is a plan. The plan can be either administered by the insurance department or it can be given to a joint underwriting association. And what happened here was the statute was passed on the end of October 1975. 6 weeks later, an ad hoc group of insurers came to the insurance commissioner with a plan saying, we'll be the joint underwriting association. And here's our plan. The statute says we're supposed to agree how to come up with a plan, and we've come up with one. Here it is. Here's our board. Here's everything we want to do. And the insurance commissioner 2 weeks later approved it.
And you didn't have to do that.
That was totally voluntary. We also filed a 501c6 application with as soon as the insurance commissioner approved that setup. And, Fred Anton, who was the first chair of JUA's board, signed off on the 501c6 application. And what he said there was that the reason the insurers wanted to do this was to protect the reputation of the insurance industry. And I'll refer you in the reproduced record. I won't read the whole thing, but at 769 to 770 of the reproduced record, you will see Fred Anton's description of why the insurance industry wanted to set up this plan. He starts out by saying the insurance industry has been criticized recently by the public because certain companies have been canceling or refusing to rewrite medical malpractice insurance. The association's activities of writing such insurance will promote the common business interests of its members by providing malpractice insurance to healthcare providers who would normally be unable to obtain such insurance, thereby minimizing public criticism of the industry. So, we've heard from the General Assembly and the governor that there's no purpose to JUA other than what the state has mandated. Well, that's not true. That's not true from the genesis.
Question back on the
yeah, I'm not sure that I've finished answering your question, Your Honor.
Is there another set of malpractice insurance or medical malpractice carriers that come to your organization to buy insurance other than those that can't get it? I mean, do you have a group of people that just say, we want JUA insurance, even though we can get it from, I don't even know if these...
JUA's actual policy, I didn't mean to interrupt you. Are you finished your question?
Yeah.
Okay, so JUA's actual policy is to take all comers. They don't require somebody to say they can't get it elsewhere. We got denied by this company or denied by that company. The whole purpose of JUA's mission is to provide insurance to those who can't conveniently get it. That's what the statute says. And so that's what they do.
What would be your percentage of business that comes from people who can get it from another provider but chooses JUA?
I don't think JUA even knows that, Your Honor, because they don't ask, as I understand it. I mean, if somebody comes to JUA and wants to be written, they get a quote. And they compare the quote to other potential carriers, and if JUA might be a better price, it might be a worse price, and there may be other factors involved in why they would take JUA or not. So I think I've covered a couple of the factors, but let me just quickly reel off, and this won't be any surprise to you, that the test that we would like the court to use is 5 questions. Does the government control the entity? We say no. Does the statute say the entity is part of the government? Clearly not. It doesn't. It is just silent on the issue. Does the entity have governmental powers? and function for as part of the government. Yeah, well, yeah, it actually has no governmental powers if you consider what governmental powers to be, things like taxation and eminent domain, and has none of that. In fact, it doesn't even have coercive powers. Its members have to join, but JUA is not the one who enforces that. It couldn't. It really doesn't have any power at all, other than the power of every other insurance company in the state, whatever that is. You know, these companies operate, they're heavily regulated, they have to comply with various insurance department statutes, and JUA has to comply with all of those things. But other than that, the insurance department's regulation is almost nil. Does the entity get its funds from the government? We've already talked about that. Absolutely not. Never a cent, not a penny. You know, this original JUA got set up outside of Fred Anton's office at the Pennsylvania Manufacturers Association Insurance Company, and they used his secretary, and they used, it was a desk outside there, and they got a phone, and they eventually got up, and when they started to get some premiums in from policies they sold, they got their own office space, and they leased it in their own name, of course. They weren't the government. They just did all this privately. And then finally, does the government entity, do the assets, where do they go on dissolution? And my colleagues are going to tell you here that where they go on dissolution has to be the state, because the state, they'll all escheat to the state. But that's not the way this works. In fact, JUA's plan says on dissolution, the board will decide where the assets go, subject to the insurance commissioner's approval.
That seems inconsistent to me, though, with the concept that the General Assembly can repeal the enabling statute and JUA could cease to exist. And I know there's implementation of dissolution that would follow, but that just seems inconsistent to me, that it's up to JUA, not up to the legislature in that situation.
Well, the original CAT fund statute gave the insurance commissioner the choice to use the JUA as the vehicle to accomplish what the legislature wanted. The insurance commissioner made that choice. He took their plan and approved it. The plan says, and always has said, that the assets are sent the way the board wants them to go, subject to the insurance commissioner's approval. Now, the General Assembly says, well, what that means then is that the money's going to go to the state. And I'm not sure how that. What I see happening as a consequence of the board's own plan and bylaws is that there might be a stalemate. The board will propose, here's how we want to distribute the assets, and the insurance commissioner says, well, I'm not going to approve that. So now we have a stalemate. I think what happens at that point is we end up in front of a court, and probably ultimately this court, as to where the money goes and whether the insurance commissioner's refusal to approve the plan of distribution had any basis. But we're not there. And so I guess the other thing that I'll say is that the assets also would follow the path of distribution under the dissolution provisions of the unincorporated nonprofit association law. And that is a sort of a decision tree of where the money goes. Basically, anybody who has an outstanding obligation gets paid, as you would think like in a bankruptcy or whatever. And then the next rung down goes according to the plan's governing principles, which would be the board's plan of operations, which would be JUA's nonprofit purpose, which would be to support physicians and other healthcare providers who are covered by JUA to be able to access insurance at a reasonable cost.
Counsel, let's assume for the sake of discussion that the legislature decides to enact some type of legislation that would pull the plug on the JUA as it currently exists. And I don't know how they do that, but let's assume that that happens. What would preclude the industry from creating a vehicle like this? I mean, obviously, ultimately, there would have to be insurance department approval of it, but is there some reason why the private sector, without the initiation by the government, could not have approached this problem on their own?
No, Your Honor. And if under your hypothetical, the legislature decided to pull the plug on JUA, say it's not needed anymore, the insurance industry thought that it was, they could reform their own association or continue the one that already exists. And as you say, they would have to apply to the insurance commissioner to get whatever authority they needed, because the statute gives them the authority without ever having had to go through that application process. I guess you could think of it that way, that Section 732 of the statute. When the current MCARE statute, when it continued JUA in existence,
But theoretically, the insurance commission would not need the approval of the legislature to approve a newly formulated JUA or, some entity like it.
Right, and I suppose if the legislature, only if the legislature for some reason didn't want this to happen, I suppose they could legislate to say that the insurance commissioner can't do that. But other than that, it's hard to imagine why the legislature would do that.
But it is possible for this entity to come into being without any legislative intervention.
Yes, and in fact, as the discussion that I had with Justice Brobson, that's how it started.
Well,
but
that's yeah. The reason why the JUA came into existence, much like assigned risk pools come into existence, is because the commercial market doesn't want to write the insurance at the rates that people can pay for them. So the JUA, the insurance commissioners and Mr. Anton, or the insurance companies and Mr. Anton came forward because the General Assembly said in the Cat Fund Act, there's a need for coverage for doctors that are high risk and can't get it in the ordinary market. I'm not sure that the industry's intentions were completely eleemosynary. I think the idea was we're either going to be forced to deal with a state-run fund, or that we're going to have to fund, that we're going to have no control over, or we can create this association, come to the insurance department and say, you don't have to create a state-run fund, we'll take care of this, we'll do it. And you have done so very well for decades in the fact that you generated a huge amount of surplus that is very attractive to the general fund budget. But I'm not sure, I think Justice Donahue is correct in the sense that, sure, if the JUA was taken away statutorily, the insurance companies that write this in Pennsylvania could come together voluntarily and form their own little high-risk pool of medical malpractice insurance. I'm not sure there's much of a motivation to do that.
Well, except it's been relatively successful, and it's certainly a viable concept given the performance.
Oh, no question, Your Honor. In theoretical terms, the conversation that you and I had, it's absolutely true that that the insurers could do this on their own. It's also probably true, and the reason why we have other assigned risk pools, et cetera, that they're not eleemosynary organizations, and so most private insurance companies, and so it may not happen that way for various practical reasons, but it certainly could.
Would you like to wrap up, counsel?
I would like to address, yes, I would, Your Honor. I have not addressed what I think is an important point, and that is the governor's issue, which is that JUA has to be the government, because in 1975, there was no such legal entity as a nonprofit association. Nonprofit associations existed, but they only could live life under the guise of their individual members. And so they couldn't acquire property, they couldn't sign a deed, they couldn't do any of those things that legal entities do. And my response to that is, and we cited this in our brief, and we briefed the issue because we figured that they would raise it in response, as they did in the federal courts, although very belatedly, since they didn't raise it until it got to the Third Circuit. After 3 separate lawsuits in the federal district court, we heard it for the first time in the Third Circuit on appeal, this issue. But the issue is that, and another reason why they would say that the JUA has to be the government is because the only way it could be a legal entity would be if it were a government entity. And my response to that is the Crumbine case, sets out the principle that, that is true at common law. An unincorporated association didn't have those rights, unless, and the major exception is, it was conferred by statute. And we would say that in the Cat Fund statute, the legislature gave the insurance commissioner this choice, essentially gave the industry this choice. The industry came back with a plan. The plan said, on almost its first line, JUA is a separate legal entity, separate and apart from its members. Insurance commissioner approved that plan, and then in the 2002 Cat Fund statute, or MCARE statute, JUA is established as a nonprofit corporation. That's another, I would call it legal imprimatur on its legal existence. And so when you have statutes that expressly do this, you get past that common law problem. So all of the argument and related argument concerning this issue we think is, a non-starter. And finally, I would just say that you're going to hear from the state parties that you should accept this creature theory, and that the creature theory, I will just suggest that the creature theory is too broad to be a useful construct. And what you need to use is the kind of test that you've developed in similar situations, and those similar situations hit the 5 factors that we've discussed, and make a determination. And I think when you look at those 5 factors through the lens of JUA's experience, you will have to conclude, if you are going to answer the question as asked, you will have to conclude that JUA is private, not public.
Thank you, Mr. McKeon.
Thank you.
Mr. Myers, you want to go next?
Good morning, Chief Justice Todd, and may it please the court. My name is Carl Myers from Stevens and Lee. I'm here today representing the legislative branch of the Commonwealth's government, the General Assembly, the Speaker of the House of Representatives, the President pro tempore of the Senate, and the minority leaders of the House and Senate. I'm here with my colleague, Paige Hogan. Just before I begin, I wanted to lay out that we're going to attempt, even though there's a single issue that's been presented for this court's review, we're going to attempt to divide the issues as best as we can to avoid duplication and argument. I know the court always appreciates that. I'm going to focus my argument on the constitutional question, so the relationship between the JUA and the Commonwealth. Mr. Kirkpatrick is going to address the question of the nonprofit unincorporated association law and other questions about the entity status. But of course, we're both, of course, happy to answer questions about our respective briefs. The question presented to this court is, under our Constitution, the Pennsylvania Constitution, is an entity that is created by the Commonwealth to solve a public policy problem fundamentally public or private?
It's interesting you phrased it with the Pennsylvania Constitution, because that's not exactly what the wording was from the third. Pennsylvania law can encompass the Constitution, but I think it's interesting that you've chosen to focus on that.
Well, Justice Brobson, and I actually wanted to get my opening spiel out before I started to address your question, but actually, my opening spiel actually directly addresses the very first question you asked Mr. McEwen, which is, the Third Circuit asked this court a very open-ended question, and I think it is fair to say that it's speculation to guess as to why it was phrased as it was. I like to think it's because the Third Circuit wanted to give this court some leeway about how to answer the question. Because, Your Honor, Justice Brobson, you're correct that this court doesn't typically, and Pennsylvania law typically doesn't tackle this kind of question by simply saying public-private, end of discussion. Rather, our courts, and under precedent set by this court, it's an issue-by-issue analysis. And that's why the JUA is inviting this court to look at cases like sovereign immunity and tax exemption and other cases of those types. But the question here has nothing to do with tax exemption or any of those kinds of other issues. The question here is a constitutional question, and it's the JUA's claim that it has the constitutional right to assert a takings claim, that the Commonwealth has taken its private property without just compensation. So the question for this court is, does an entity like the JUA have constitutional rights it can assert against the Commonwealth that created it? The answer to that question is emphatically no. It does not have those rights. Tellingly, and we called this out in our brief, the JUA cites no case in Pennsylvania history where this court or any other court, or frankly any other court across the nation, has said that an entity created by a state to address a public policy problem has constitutional rights it can then turn around and assert against its very creator. And there's good reason for that, and that's because there's legions of cases that say the exact opposite of that proposition. Mr. McCune has said that we have this theory about the creature of the state, that it's a theory. And the suggestion is that we've invented this, that this is some kind of concoction that we've generated for purposes of this case. No, that concept is embedded in ancient constitutional principles. It's in Trustees of Dartmouth. It's in City of Trenton. And then it's been carried, and those are U.S. Supreme Court cases. And that's been carried forward in this court's precedent. So it's in the Fox case, it's in the Chester Institutional District case. And what those cases say is that the states create entities to carry out governmental functions. These are essentially, in the Fox court's terms, they're revocable agencies that carry out the essential operations of government. Now, we can put labels on them like agency, commission, board. The label, instrumentality, the label does not matter. The simple reality is that these are legislatively created bodies, putting, of course, aside those entities that are set up by Constitution. So, for example, Article 5 gives this court the domain over the judiciary. Other provisions give the governor exclusive powers. But outside of those constitutionally committed powers, the General Assembly has a free hand to organize and reorganize the internal affairs of the Commonwealth. And
you did say essential operations of government.
Yeah.
How is providing medical malpractice insurance an essential operation of our Commonwealth government?
Well, it's within the police powers of the General Assembly. Maybe I misspoke, or maybe I spoke too narrowly.
It's not essential, though.
I didn't say it was limited to that.
You did say essential. You said essential operations of government. That's what you said.
Yes. Yes.
Is the providing of medical malpractice insurance an essential operation of government, unlike saying providing for a public education?
It is actually, and I don't want to get too wrapped up in this essential, non-essential.
Well, but it's important, right? Because it is important because there are a lot of entities that are statutorily created that no one would argue is part of the Commonwealth government. Correct. The blues plans, for example, would not exist in Pennsylvania under the professional health law in Pennsylvania if they weren't statutorily created. They were authorized and created by statute. Any corporation in the Commonwealth of Pennsylvania exists only because the General Assembly enacted a statute that authorizes the creation of corporations and applications and approval from the Department of State. You're not suggesting that they're public.
No, I am not. I'm not. The distinction to be drawn in the question of the creation of a corporation is, it comes back to the fundamental, what we call the Dartmouth question. We've been litigating this for 6 years, so now we're using shorthand. But the Dartmouth question, it's the U.S. Supreme Court decision from 1819 that basically says that when you're looking at fictitious entities like corporations or other business entities or business-like entities, the question you have to ask for purposes of the question presented here, which is, does this thing have constitutional rights it can assert, is who created it and why? Was there a private interest behind it?
Sorry to interrupt you, but this goes back to my problem is you're almost asking me to resolve the Third Circuit issue, the question of whether the JUA has constitutional rights. That's not the question that we have in front of us. We simply have in front of us the question is the JUA public or private?
But I think, again, that this court's analysis is an issue-by-issue analysis, and the court doesn't need to resolve the federal constitutional question. The Third Circuit's question, I think, can appropriately be characterized as a question of asking, is there a state property interest? Because state property interests are typically determined by state law. Does the JUA have a state property interest it can assert? That's the easier or narrower way that it can be phrased that is consistent with the issue-by-issue analysis. And so,
I really wish they would have asked us that question.
Yeah. Well, if carrying that through line, and I think the court can write an opinion that doesn't necessarily make a broad declaration that the JUA is public or private, because I will readily concede that in another context, under another set of facts, it may be appropriate to find that the JUA is not public for all purposes at all times. So, for example, if a policy claim was made by somebody under the policy, then it might be deemed private for those purposes. And so I think when the court authors its opinion here, I don't think it necessarily needs to stick its neck out and say the JUA is public for all purposes. Well, it just needs to say for this case.
Well, let's explore that then for a second. If when a medical professional presents a claim to the JUA under a policy, and the JUA does not pay, do they sue in the Board of Claims?
I don't think the answer is no. I don't know. We actually developed discovery in this case. I don't think there actually has been a situation where that has arisen. I don't think it would go to the
But if
board.
it was a Commonwealth government agency, that would be where it would be a breach of contract action. You'd have to go to the Board of Claims.
If it was a Commonwealth agency, right. And that comes back to...
If it was the public, you would also sue in Commonwealth court.
I'm sorry, I didn't hear this.
If it was a Commonwealth agency, you would also arguably you'd have to choose between Board of Claims and Commonwealth court, right?
If it were a Commonwealth agency. But again, I want to emphasize what I said earlier. It's an issue-by-issue analysis, so we're not suggesting that necessarily, Justice Brobson, needs to be the end result, that everything about this needs to be deemed public. It's just on the facts presented, the relationship between the JUA and the Commonwealth that created it. Is that a public relationship or is that a private relationship? The JUA's other relationships, whether it be with a policyholder or another, that might be deemed in another context a private relationship. But here the question is, what's the nature of the relationship between the JUA and the Commonwealth that created it to solve a public policy problem? And that fundamentally is a public relationship. I wanted to address some of the questions that have been asked of Mr. McCune. Chief Justice Todd and Justice Dougherty, you asked the question about the repealing of the statute. Couldn't they just repeal the statute? Well, in point of fact, the General Assembly has repealed or amended the statutes that affect the JUA. And that's part of why we're here, because while the JUA was created by statute in 1975, and actually I need to drop a footnote and clarify some things about this notion that this was a voluntary decision by the insurance industry that said, and Justice Brobson, unfortunately, stole some of my thunder on this, that this was the insurance industry coming to the Commonwealth and saying, we want to help you fix this public policy problem. No, not by any stretch of the imagination. This happened. The JUA exists because the Commonwealth made it happen, not because the insurance industry did this on its own. Section 801 of the 1975 statute says the commissioner, the insurance commissioner, shall. That's a legislative command directing the insurance commissioner to do something about this and create this public option.
It said to do something. It didn't say to do this.
It did, actually. It's, again, and this was a legislative policy choice. The legislature said, okay, we will let the commissioner, again, a Commonwealth actor, not private industry, the commissioner make a decision. You can either, Commissioner, have this as something within the insurance department, a la the MCARE fund, or you can basically tell the industry, you're going to do this as a mimic.
You're causing Fred Anton to roll over in his grave.
Well, but I mean, there's been much made about this happening at Fred Anton's desk and using Fred Anton's phone. And when I hear that, and I hear all these other ancillary things that describe the JUA and they sound like they're private, I shrug my shoulders because I say, so what? None of this would have happened this way but for the General Assembly opening the door for it to happen and for directing the commissioner to make that choice.
But by giving the commissioner that choice, though, doesn't that choice that she makes matter in terms of whether it's government or whether it's government regulated? Because insurance departments are government regulated, or insurance companies there's a lot of government regulated entities out there that nobody would say they're the government. So when the General Assembly gave the commissioner this choice, wasn't a choice between government and government regulated, and she chose government regulated.
That's also a fallacy, Justice Brobson. And throughout the JUA's brief, it constantly says that the commissioner had a choice between a government option or a non-government option, and constantly, like a drumbeat, refers to this plan option as a non-governmental option. The problem is the statute says nothing about that being a non-governmental option.
I know, I understand, I understand that it doesn't say that expressly. I mean, but it is. There were two choices, and you're saying both choices were government options.
They are both government options because the insurance commissioner said, the statute says, Commissioner, we're commanding you. We're the legislature. We're making the decision here. But we're fundamentally making the choice to provide two options. One is you put it within the insurance department. The other is you approve and supervise. That doesn't change the fact that it's still a governmental program and a government-run and government-supervised program. All that this approval.
Why is that not exactly what happens with every insurance carrier? They're regulated by the insurance department. They're supervised by the insurance department.
But their interest, I'm sorry, Justice Donahue, were you finished? Oh. So the difference is that for a private insurance company, the interests that underlie the private insurance company and the source of the private insurance company's interests are inherently private. The who created it and why are inherently private. The difference here is the who created it and why are governmental. And
you could say the same thing about the blues plans.
Well, the blues plans, I believe they were authorized, and they may have been chartered by Commonwealth law, but those were set up as corporations, and there are other stakeholders that actually have an interest in the operation of the blues plans. And I candidly do not admit to still being an expert on the blues plans, but I think there are material distinctions between the blues plans as nonprofit corporations and this entity, which isn't a corporation of any kind with any stakeholders, doesn't have stockholders, it doesn't have.
Well, the blues plans don't have stock shareholders either; they're member nonprofits, and so, but they're, to your point, are under the statute, their purpose is purely charitable.
That is correct.
To the public, to ensure the people of last resort in the Commonwealth of Pennsylvania. That's their charter.
I don't know that I would necessarily characterize it, Justice Brobson, as charitable, because it's meeting a public policy and a public health need. The whole idea here, and in the 1975 and the 2002 acts, they both state that the purpose of these acts and the purpose of the JUA are to protect public health. I mean, first and foremost, the main purpose is let's make sure that people that are injured by a doctor's malpractice can make a claim and be compensated for their injuries. Number two, let's make sure that there's available health insurance so that doctors can practice medicine. And three, let's make sure that there is that insurance so that there's access to health care for all, that we have enough doctors that can provide for people. So I'm not sure that I would characterize it as charitable so much as it's intended to address a public policy problem. I don't know if that answers your question.
No, it doesn't. I'm just I'm keying off of your idea that the JUA doesn't have a private motive. It's because it was authorized by statute. And that's somehow the fact that it doesn't have a private motive differentiates it from a regulated entity versus a governmental entity. And my only point is the blues plans are in that exact same situation. So is PLEGA. So are all the life insurance health guarantee associations. I mean, I could go down a list of entities that are statutorily authorized that every argument you're raising would make them public.
Well, and that's actually why I was trying to draw a distinction between a charitable organization or one that is intended to help those less fortunate, like the blues plans, or at least ostensibly that's part of its mission, versus the JUA and the guarantee associations and all those similar entities, which those are all statutory creations by legislatures that are meant to address public policy problems.
So you would,
in the
you
JOA,
would agree the guarantee associations are government, are public and not private?
as to their relationship to the Commonwealth of Pennsylvania, they are public because the General Assembly created those bodies to, again, address a public policy problem. In that situation, for the guarantee funds, it's the risk when a for-profit or insurance company or another insurance company goes belly up. Who pays those policies?
You don't have to be for-profit insurance.
Well, okay, the insurance carriers, what happens if they go belly up? Who is there to make sure that claims are paid? And so that's why there's a legislative mandate to set up those guarantee funds to ensure that the policyholders are protected when a claim is made if their carrier goes belly up. So the GAs and the JUA, I'm sorry, I'm lapsing into industry speak, the guarantee associations and the JUA, those vis-a-vis their relationship to the Commonwealth, they serve a public function. Their nature fundamentally is public.
Counsel, let me just
Sure.
follow up on that. If for some reason the JUA had insufficient funds to carry a claim, the government wouldn't cover it. It's their liability.
Well, so...
And they have private borrowing authority. They don't go to the government to cover a claim, hypothetically, that they couldn't cover.
And they're expressly non-recourse to the Commonwealth.
Correct.
And I would add, everything that Your Honors just described, those were legislative policy choices. The legislature made the decision. Originally, it set up the JUA that it would get excess coverage or gap coverage for unpaid claims or deficiencies from the CAT fund. So a governmental fund would cover its deficiencies. And then the statute was changed in 2002 and said, now JUA, you have to go out and get a loan. You would think that means if the JUA was private, it would have sued and said, you can't make us go get loans because we're part of the government, but that lawsuit never happened.
Because they don't think they're part of the government. I mean, what you just described is an express disassociation by the Commonwealth from that JUA.
Well, what I'm...
Don't look to us if there's a problem.
Well, so this actually gets to the fundamental question here in the General Assembly's view, which is, this is a case about legislative power. Legislative power is not conditioned on how close the General Assembly or the Commonwealth keeps an entity to it, or how closely it supervises. Every day, work is going on in townships and counties and school districts across the Commonwealth, and the General Assembly is not micromanaging what goes on in those entities. But those entities are inarguably creatures of the state subject to the plenary power of the General Assembly to create, change, modify, or destroy them. So simply because the General Assembly has elected as a legislative policy choice to give the JUA a degree of freedom in its administration of a public function pursuant to a statutory mandate, that doesn't represent giving up legislative power or creating a private entity. That actually is good government. That's a legislative policy success story. And so if the JUA has made all this money and now has a $300+ million surplus, I frankly think that we should be congratulating the legislature for saying we're going to choose to mimic for our public option the things that work from private industry. And it worked. But that's not the product of free will or private choice. That's a product of public policy choices by the General Assembly. I think, unless the court, I have much more I could say, but I think I've taken a lot of the air out of the room. Unless the court has further questions.
Well, you can rely on your brief for any of your other arguments if you'd like.
Of course. We would just simply ask, in summary, for this court to declare the JUA public as to its relationship to its Commonwealth creator. That's what we're asking for. Thank you. I'll pass it to Mr. Kirkpatrick.
Let's hear from Mr. Kirkpatrick.
Madam Chief Justice, Justices, may it please the Court, my name is Sean Kirkpatrick with the Pennsylvania Office of Attorney General, here on behalf of the Governor and the Insurance Commissioner. And to get to, I think, the seminal question in this case, which is JUA public or private, that is not, as Justice Brobson recognizes, a question of is JUA a arm of the Commonwealth, is it an agency of the Commonwealth, is it a local agency, is it however you want to describe it for purposes of the right to know law or for real estate taxes. Is it public or private? And if I can just step away from the money for a second and focus on other aspects of Act 41, Act 44, and Act 15, which was the General Assembly's desire to change what it created. And in fact, in Act 44, there was actually a sunset clause that got enjoined. And then when the General Assembly attempted to modify the JUA, that got enjoined. So this comes back, it's again not focused solely upon whether JUA, for example, whether the Commonwealth Court has original jurisdiction necessarily. It's a much more fundamental question, basic question, which maybe is why it seems so illusory. Is it public or is it private such that the General Assembly cannot make any alterations to what it created? And if I can go to...
Again, Mr. Kirkpatrick, that's not, first of all, I'm not sure the General Assembly created it. The General Assembly authorized its creation. But in the original Catholic law, there was no provision that said, there is hereby created a joint underwriting association that shall be administered by the insurance department, that shall consist of a board of directors of 9 people, that shall have this charge, that shall have that, shall have this. That's not in the original statute. You agree?
I agree, Your Honor. However, that statute was then repealed.
I understand, but this has been a continuous entity from its beginning. So the idea that the General Assembly created it is not accurate. They authorized its creation, much like they authorized the creation of corporations.
Here is the fundamental difference between that, Your Honor. With a corporation, you have individuals coming together. They use a statutory structure in order to decide to incorporate an entity. JUA was not incorporated. It was an unincorporated association. And yes, if we accept the origin stories about sitting in desks outside of offices, here is what the CAT Fund legislation allowed the commissioner to do with this entity. And this is Section 808 of the Malpractice Act. If the private insurance market, and the legislation or the General Assembly is saying, okay, well, this plan isn't part of the private insurance market. If the private insurance market unfairly discriminates against higher risk physicians by denying professional liability insurance coverage under certain conditions, the commissioner, after notice and public hearing, may declare the plan, in this case, JUA, established under this article, shall be the sole and exclusive source of professional liability insurance for healthcare providers within this Commonwealth. The commissioner may dissolve the plan if he determines it's not needed, may reestablish it if he decides that it is needed, if he finds, quote, that the private industry has failed to provide an adequate market. So this JUA was a cudgel to be wielded by the commission. If it was a private entity, I think we get into sort of monopoly and Sherman Act problems if the commissioner can say, well, this entity that I've allowed, this private entity that I've allowed to be created, guess what? All the other private companies no longer can be in this marketplace. This sole thing, this private company, private entity is the sole source of insurance, medical malpractice insurance in Commonwealth. That was never the intent. The intent was always, and this ties into our argument about why it's important that the Uniform Unincorporated Nonprofit Associations Act was postdates the creation of JUA by 30 years. The intent was always that JUA act as an essential part of this regulatory regime. And it was first with the CAT Fund, and then the General Assembly did what the General Assembly is allowed to do, completely repealed that, and says now we have the MCARE Fund, and we are establishing the JUA as a unincorporated association. And it can, in the future, decide to completely repeal the MCARE Act and do something else. And that's what it has attempted to do through Act 41 and Act 44 and Act 15 is say, JUA, we're now going to say, before we didn't say how your board had to be comprised of. We are now. JUA, you didn't have to be in a public building, now you do. You have to be under the right to know law. You're worried that there's a deficit. Well, congratulations, you now have access to public funds. And so whether it is a Commonwealth agency for purposes of a statute, this is why we don't think the multi-factor test proffered by my friend is very useful, because the real question is it public such that the General Assembly can change it? Or is it private, which means it inherently has its own status and rights under both constitutions?
The General Assembly can change anything. The General Assembly could enact changes to the nonprofit corporation law tomorrow that impact nonprofit corporations. It's sort of a simplistic analysis, because the answer to it is obviously yes. Obviously, yes, the Commonwealth could pass legislation to affect any number of entities operating in the Commonwealth. A municipality could pass a zoning law that affects our municipalities. They can enact a tax statute that taxes an industry that wasn't taxed before. They can do it. I mean, that's just it's an incredibly simplistic question. And I'm not sure we can answer this public versus private by simply saying, can the General Assembly regulate, legislate, or change something in existence? Well, yes, they do it all the time.
No, and that's exactly right, Your Honor. They can repeal the Business Corporation Act, and suddenly there's no corporations left. But in those cases, because it was incorporated under as a separate entity, and because there are private parties who have interests in the money and the assets of the corporation, that has certain ramifications for purposes of the federal Constitution. Here we have an entity that was created by statute. The General Assembly has attempted to not amend a statutory framework that covers a wide variety of different corporate structures or corporate entities, but rather laser focus in on the thing that it established in MCARE and say, okay, now you're different. That we have a district court that says because that entity is private, you can't do that. And what we're saying is we have to be able to do it, because that's what the General Assembly does. It amends its laws, and what it created, it can therefore amend, or it can repeal, as it has done with JUA back in 2002, and as it has done with a variety of other insurance pools. On the issue of the MCARE Act, I will also point out that the statute, again, contemplates JUA as not just being another private insurance company. It says that JUA is required to provide reasonable means for the health care providers it insures to transfer to the ordinary insurance market. The idea being that JUA, we're going to tell you you have to cover certain individuals that originally we thought was going to be, well, frankly, back in the 1970s, that the private market didn't want to touch. And because that was affecting the number of doctors in Pennsylvania, we're going to establish a entity or establish a plan that provides for the establishment of an entity that ensures that. We're going to repeal that in MCARE, and we're going to reestablish it. There's been some discussion about dissolution. Originally, under the CAT fund legislation, the commissioner had that authority, stroke of his or her pen. It's gone. It's come back, reestablished. The General Assembly in MCARE said, no, that's our call. The law says you are established. You don't get to decide if you want to dissolve or not.
So the plan, and this, I think this will be other litigation, right? Because the original plan that was approved by the commissioner establishing the JUA, there was no separate new JUA created. It was a continuation. So the legislature essentially nullified the provision of the original JUA plan that talked about dissolution.
The original plan, and this is also the current plan, talks about, and I'm blanking on the exact term, but essentially, as the law provides, under the law, well, you know, if dissolution happens.
Doesn't it refer to the board of directors of the JUA with insurance department approval?
Yeah, it does.
Right.
It absolutely does. But
so that's the original plan that was approved by the commissioner under the law that prevailed at the time.
yes,
And you're saying that the General Assembly can later pass by legislation something that nullifies the content of that plan.
that amends amends the JUA. Absolutely.
That's not what I said. But that nullifies the plan originally approved by the commissioner.
Well, I don't like the word nullify.
I know.
Well, the plan of operations then was changed in response to the MCARE Act being passed. JUA changed its plan of operations to acknowledge MCARE, to acknowledge that it is under a new statute. So it didn't sue and say, you can't do that, we're a private organization. It said, yes, sir.
Oh, come on, Mr. Kirkpatrick. It chose its battle. It didn't. I mean, really, they made a decision. I mean, to say they were somehow that decision reflects an acknowledgement that they are subject to the will of the General Assembly for all purposes isn't a stretch, isn't it? Maybe it was just we're going to work with the General Assembly here.
Well, I wouldn't want to stretch, so
okay.
I won't.
Okay.
And they may have been involved in the development of the new protocol in terms of lobbying and otherwise. I mean, that's likely.
Because again, they are not just another insurance company. They're an essential part of a regulatory regime that exists to ensure that in the private market can't exclude certain medical providers. So again, we sort of come back to this idea that is it public or private? One, and we would say that is a broader concept than just simply, are you a agency of the Commonwealth for purposes of tax policy? On the Uniform Unincorporated Nonprofit Association laws, and why this is important, I want to make this clear, and we say this on page 46 of our brief. We are not saying that the JUA, when it was created in 1975, couldn't act or sign contracts under its own name. We're not saying that at all. We recognize that the CAT fund legislation provided the legal status it needed because obviously at the time there was no law that generally allowed unincorporated associations to act under its own name. I will note that with the passage of the Uniform Unincorporated Nonprofit Associations Law in September 2013, Section 9126A1 of that law says, a person may not be admitted as a member of an association without the person's consent. And I want to focus on my friends suggest in their brief that joining JUA is in fact voluntary because you can just not do business in Pennsylvania if you don't want to do it otherwise. We respectfully suggest that that's sort of the mentality perhaps the mafia has when they come into a store and say, very nice business you have here, I'd be ashamed if something happened to it. It's compulsory. The person's consent, there is no illusion of voluntary choice. It's essentially like jury duty. If you want to sell this type of business, you must join the JUA. That is a power, I think, unique to JUA.
Well, if you transact the business of insurance in Pennsylvania, you have to pay premium tax.
Yes, but they don't say you have to pay premium tax to a specific entity necessarily.
I'm just saying that whether it's compulsory or not, I'm not sure it matters. If you choose to engage in the insurance business in Pennsylvania, and the JUA pays premium tax, by the way, which is interesting that they're public, but they pay taxes to the public. But that's okay.
Their choice.
Well, you're right, exactly. So whether it's compulsory or not, I don't think is a differentiating factor of whether they're public or private.
Here's why I think it's important, Your Honor. Because if it wants to be decoupled from the Commonwealth, it needs to have statutory authorization. It needs to say, okay, under Uniform Unincorporated Nonprofit Association law or under some other understanding of what an association is, the General Assembly was allowing the commissioner to authorize creation of a private entity, an incorporated or unincorporated entity separate from the regulatory regime. An association has always been under common law and now under the nonprofit associations law, always been understood as a voluntary joining together by private parties for a common good. This is compulsory. This is not just a regular type of association. This is, like I said, equivalent to jury duty, in which the Commonwealth says, if you want to play in Pennsylvania, you have to join this and you have to participate. And so the idea that this was just spun off and lived separate from the regulatory regime since its inception, I think, is ahistorical.
Any other questions? Would you like to wrap up, or was that it? That sounded like a wrap-up to me.
I think that was a pretty good wrap-up, Your Honor. Thank you very much.
Congratulations. I want to thank you all, Mr. McCune, Mr. Myers, Mr. Kirkpatrick, and Ms. Hogan. Those were excellent presentations today. We'll take it under advisement. Mr. Minner, we're going to take a recess until 12:30. afternoon. Few of you left. I guess the interest in our docket is waning. Our next case, would you call it, Mr. Minner?
Thomas E. Bold Jr. versus PennDOT, representing Mr. Bold, Mr. Edward Spria Jr., representing PennDOT, Mr. Terrence Edwards.
In this discretionary appeal, a police officer found appellant passed out while sitting in the driver's seat of his vehicle, which was legally parked with its engine running and headlights on. The officer suspected appellant was intoxicated, but appellant refused to allow a blood draw to test his alcohol content, ultimately resulting in the suspension of his driver's license. We accepted review to address whether, under these circumstances, appellant was driving, operating, or in actual physical control of the movement of a vehicle for purposes of license suspension provisions of the implied consent law.
Thank you. Good afternoon, Madam Chief Justice, Justices, Mr. Edwards. My name is Attorney Ed Spria on behalf of Thomas Bold, the appellant in this case. Mr. Bold's position is that the Commonwealth Court erred when it ruled that the Commonwealth was able to establish that they had reasonable grounds to suggest that he was in operation of a motor vehicle while under the influence of alcohol, and that this was in direct contravention to existing case law of this court in that area that requires a showing that the operator of the vehicle actually drove the vehicle prior to coming into contact with law enforcement. It was an uncontested fact in this case that the officer, when he arrived at the scene, found him in the bar parking lot, and that the officer credibly testified that he had no question that Mr. Bold actually exited the bar, got into the vehicle, started the vehicle where he was found without ever having driven that vehicle. And the cases that this court has decided started with Commonwealth v. Byers, which is a Superior Court case, where the Superior Court found that there must be a showing for actual physical control, that an individual drove the vehicle prior to having contact with the police. The Byers case was adopted by this court in a criminal context in Commonwealth v. Woolen, and it was also adopted in a license suspension appeal in Banner v. the Department of Transportation Bureau of Driver's Licensing, where this court specifically found that actual physical control requires a showing that the motorist drove the vehicle prior to coming into contact with the police. In the Banner case, the court found that the line must be drawn to distinguish circumstances where a person drove while under the influence, which the statute was intended to prevent, as opposed to circumstances where the defendant is physically in a vehicle after becoming intoxicated, which is what we had in this case. It differs in the fact as to whether, yes, in that case he was sleeping along the roadway, the engine was off, the lights were off, where in this case he was sleeping in a vehicle with it running. But as the court defined actual physical control shows, and showing that the person drove, there has to be a finding that the person drove the vehicle prior to that. So I think the argument that can be made would, and to be looked at, it depends on the facts of the circumstances, whether a vehicle is on or a vehicle is off, may not necessarily. And I think in those circumstances, it still hinges on whether or not the Commonwealth can establish the person drove the vehicle prior to police contact, as opposed to the location of where they are in the vehicle. It shows that you have an aspect of control. However, the existing case law that deals with these situations all lay out that you need more than just that aspect to get a conviction for driving under the influence of alcohol, which is required under 1547.
He might have just wanted to have the heater on.
kind of the heater on, the air conditioning on. The analogy I made with the Commonwealth Court was Saturday afternoons up in State College where all the individuals have RVs. It's not uncommon for the individuals who consume alcohol at the tailgates to start up their RVs after the game to stay in an RV, to sleep it off or to run a generator, whatever the case may be, where that's a situation that the vehicle is being turned on with no intention to ever drive that vehicle.
What did the General Assembly mean, in your judgment, when it used the terms actual physical control of the movement of a vehicle?
Well, what the Byers case indicates is that in 1992, that's when that amendment was added by the General Assembly. Prior to 1992, the language actual physical control was not part of the statute. That was added in 1982, rather. And what the Byers Court, the Superior Court, found in that was that it was added to cover circumstances where people drove a vehicle prior to coming into police contact. Where, for instance, if someone's found on the side of the road, miles from a bar, engine running, no inclination that they parked the vehicle there and walked miles back and forth to the bar. But when the police come across the vehicle, it's on the side of the road, and all indications the person drove there. That the Byers Court indicates that that's why actual physical control was added in 1982 to account for those circumstances where the person drove before the police got there. However, the police did not see them actually moving the vehicle.
So it's a reasonable inference test?
It's a reasonable inference test.
As to whether there had been movement recently?
Prior, yes, while the person was intoxicated, yes. And I believe that's the way the court looks at that. And it has looked at these cases on both sides. Through the Superior Court, there's numerous cases, and there are Commonwealth Court cases that also deal, as well as Supreme Court cases, in situations where people were not found actually moving the vehicle with the vehicle in motion. So then
that was Judge Levitt's view in dissent at the Commonwealth Court.
And Levitt's, yes, Judge Levitt's view was that the Commonwealth Court, the majority erred in following the Vinansky case when it should have followed the Banner case, as well as the Commonwealth Court's own decision in Solomon v. Bureau of Driver's Licensing.
The problem is, I mean, there's these three statutory things of circumstances that we have to give meaning somehow, some way to all three of them. And I'm trying to figure out whether yours is a statutory construction case or you're simply saying the predicate facts known to the police officer at the time were not there, such that he should have even been asking for the invocation of implied consent. The predicate facts that seem to be undisputed here is the guy came out of the bar. He was never in, he never drove the vehicle, and therefore never could have been accused of drunk driving. And that could end the case without us even examining the statutory construction.
In some ways, Mr. Bold would argue that, yes, that would be the case, that we never got to that level. Because 1547 of the Vehicle Code requires that there be a showing that an officer had reasonable belief that the motorist violated 3002 of the Vehicle Code.
And the reasonable belief is one of those three circumstances, that the driver was either driving, operating, or in control of the movement.
Actual physical control, yes.
And so driving, I think we all know what that is.
Sure.
Actual physical control, you mean past tense, meaning at some point in time had actual physical control over the movement.
That's the way that the Byers Court seems to define that, yes.
Then how would you define operating?
I think an operate would be more than just, because operating a vehicle could be putting the windows down, turning on a radio. It has to be more than just having some sort of control of the physical operation, more than just putting the windows down, opening the door, pushing a key fob that would start the engine remotely.
Why does it have to be more than that? I mean, what about the statutory language are you relying on that requires us to interpret the word operating so narrowly?
And I think it would be a combination of the combination of all the factors. And I'm not sure, I'm trying to think the best way to answer that question. But when I view the existing case law that deals with operate, operate has always been found, and I don't have a case off the top of my head, but operate has always required more than just sitting behind the wheel of a vehicle.
I think we're here because the case law is not very clear on what operate means. Again, I think it's very clear on what drive means. I think it's somewhat clear on the movement question. I think, though, the operating is really where it can't be drive, right? Because it can't be something that is, the General Assembly doesn't mean to say the same thing twice. It can't be what you said, meaning at some point in time having had control over the movement. It has to be something else. So without telling me whether he was driving or had control, what facts would we have to prove operating?
Something more than being behind the wheel of a vehicle.
Like what?
When it started. Something with an individual trying to take steps to move the vehicle. For instance, I believe...
By that time, he's drunk driving.
Well, and there's a situation, I think, that comes to mind, that there's the James case that the Commonwealth cites in its brief, where a car was in the process of being towed, if I recall the facts specifically, and the person saw that the car was being towed and got into the car attempting to get away from the tow truck, but was not able to based on the fact that the vehicle was hooked up to the tow truck.
That wouldn't be driving?
I would think, well, in that situation, it could be argued that the vehicle never actually moved on the road. It was attempted to move, so in that could be where the operation comes into play, that he started up a vehicle attached to a tow truck, if I'm remembering those facts correctly, and then attempted to pull it off the tow truck, but was unsuccessful because it was attached to that object. So in that situation...
So operating is attempted driving?
In some circumstances, I think it could be.
Could you give us any other examples of where operating is not driving?
I'd have to rack my brain to come up with some. So off the top of my head, no, and if I don't want to belabor that while I try to brainstorm an idea.
Well, there's Ballantyne, right? Did you read the Ballantyne case?
Ballantyne was the civil tort case that the Commonwealth relied on, where a vehicle was parked on the side of the road, and I know the Commonwealth Court declined to extend to the tort definition of outlined in Ballantyne, where the vehicle was parked on the side of the road. And I think the Commonwealth Court in a footnote mentioned, I think that's where the operating the windows up and down came into play, if I recall correctly.
Yeah, I want to come back to Justice Brobson's line of questioning, because putting aside Commonwealth Court and Superior Court decisions of the past for a moment, and focusing on the word operate, and taking into account our opinion in Ballantyne, can you tell us why we should not construe operating under this operates under this statute to include circumstances where somebody turns the ignition on, whether with a key or a button, and turns the heat on? Because which side of the line should we fall on, and why?
I would suggest that you would fall on the side of the person in that situation is attempting to sleep it off. And there are cases where the court has talked about that, including Byers. And that's something that that this court addressed in Banner when it said that it's important to have a line that's drawn to distinguish circumstances where a person drove under the influence, which the statute was intended to prevent, as opposed to someone who physically entered a vehicle while they're intoxicated and while they're impaired.
And Officer Gelnet testified here that his deduction was what?
His deduction was that the individual left the establishment, entered his car, and turned on started the vehicle to sleep it off because it was a cold night, turned on the heat. And that was a fact that was essentially admitted to the officer, and he said, yeah, I don't doubt in my mind that that's what this person was doing in this case.
So your proposed definition would be operating means anyone that starts a car with a specific intent of driving it.
Or something more than just turning on the heat or the air conditioner or putting down the windows or turning on the radio.
The driving intent is what you want us to focus on. There has to be an intent of some sort to operate the vehicle for purposes of driving it, not for some other purpose, which makes it a truly factual inquiry if it comes up.
And most of these cases are very, very fact-specific, based on location of the vehicle, engine running, whether a person slumped over the wheel or slumped over the passenger seat, or seat being reclined as opposed to sitting up in the driver's
Well, your facts are different a little bit because of the situation with the officer basically saying, yeah, I believe he slept it off in the car. The other cases that we see a lot, or I saw a lot of the Commonwealth Court, are the cases where the car is on the side of the road, the engine's running, and the person is slumped over the wheel.
Or even the Vinansky case, which is what the Commonwealth Court relied on, where the person was found outside a drinking establishment, but the Commonwealth Court, in that decision, found that a reasonable inference could be that Vinansky drove to that location but was too impaired to exit his vehicle and enter the establishment.
Whereas here, Officer Gelnet testified that he concluded or believed that the guy had come out of Permanis, turned the heat on, and was trying to sleep it off. Is that
had no intent to drive?
No.
Exactly.
So
that was.
Let me ask you this, if I may. Should we attribute significance to the fact that the statute uses the words in actual physical control of the movement of a vehicle as opposed to in actual physical control of the vehicle? In other words, there could be no dispute that, I guess, unless he was totally unconscious, that he was in actual physical control of the vehicle, right? I mean, he was sitting in the driver's seat. Would you maintain that he did not have physical control of the movement of a vehicle, or am I off on a wrong tangent?
And he was unconscious, right?
He was sleeping it off when the officer arrived. Yeah, that was, and that's where I rely on, because actual physical control seems to be a rather broad concept when you think about the different concepts with operate and actual physical control. And that's what I rely on the Byers case, where they define actual physical control to deal with specific circumstances where the person drove before, and that there's a requirement to show that the person drove. And specifically with 1547, it's important to note that prior to 1990, or prior to 2003, the language was that an officer had reasonable grounds to believe that the person drove, operated, or was in actual physical control while under the influence of alcohol. That changed in 2003, where the language is now while in violation of 3802. And that's a different standard. At least we would argue that that's a different standard. Well, the language that still is used by the courts, including I used it in my brief, the Commonwealth Court used it, was the language about while under the influence. But I think we need to take it a step farther and say while in violation of 3802 DUI, which requires a showing the person was violated the 3802 section, driving under the influence of alcohol. And to violate 3802, you actually have to drive the vehicle as required by Licen and Byers.
Except that the implied consent law serves a different purpose.
Well, I believe that's addressed by Banner. Well, Banner, this court, in a license suspension implied consent case, indicated that there must be a line drawn to distinguish between the two circumstances. Thank you.
Thank you. Hear from Mr. Edwards.
Good afternoon, Chief Justice Todd and Justices of the Supreme Court of Pennsylvania.
Good afternoon.
May it please the Court, I am Terrence M. Edwards, Governor's Office of General Counsel, representing the Commonwealth of Pennsylvania, Department of Transportation, Bureau of Driver Licensing. I think the Court has hit the nail on the head with its questions. This is a statutory construction case. So there's two sections from the Rules of Statutory Construction I'd cite to the Court. First is 1 PACS section 1921C5 that says, when the words of a statute are not explicit, the intention of the General Assembly may be ascertained by considering, among other matters, the former law, if any, including other statutes upon the same or similar subjects. The other is 1 PACS section 1922-2, which provides, in ascertaining the intention of the General Assembly in the enactment of a statute, the following presumptions, among others, may be used. that the General Assembly intends the entire statute to be certain. In the 1959 Vehicle Code, and this was former 75 PS Section 624.1, which was the implied consent in the 59 Vehicle Code, it spoke of person shall not, or a person who operates a motor vehicle and a police officer having reasonable grounds to believe the person to have been driving while under the influence of intoxicating liquor violates the implied consent law if he or she refuses. The Act of June 17, 1976, which enacted the current Vehicle Code, effective in 1977, provided that any person who operates a motor vehicle in this Commonwealth shall have, and the officer will have reasonable grounds to believe the person to have been driving a motor vehicle while under the influence of alcohol. The language was the same for both. However, there was one big change with the 76 version. In the 59 Vehicle Code, a person was not allowed to operate a vehicle while under the influence. The 1976 version provided that a person could not drive. As the Commonwealth Court indicated in the Farnery decision, which is cited in our brief, there apparently is a problem with that, primarily because the criminal courts were construing the word drive much more strictly than the word operate. And consequently, in 1982, as Mr. Spria alluded to, the Act of December 15, 1982, changed both the DUI law and the implied consent law to provide that any person who drives, operates, or is in actual physical control of a motor vehicle shall agree to, or shall be deemed to have given consent if a police officer has reasonable grounds to believe the person drove, operated, or was in actual physical control of a motor vehicle while in violation of the DUI law.
So could I interject there?
Certainly, John.
It still takes us back to the nub of this case. I mean, in other words, a little bit question begging, because it still circles back to the question of how we apply the legislature's words to these facts. So the facts as we have them, and correct me if I'm wrong, is that the officer testified that consistent with Bold's testimony, he got drunk, he went out to the car, turned it on to sleep it off with the heat on. Do we, if to the extent we're trying to channel the General Assembly's intent, do we want to think that they wanted to encourage people to sleep it off and not drive? I'm just trying to imagine what a reasonable legislator would have intended here.
Your Honor, our position is that there are three terms, and Justice Robson's alluded to this: drive, operate, actual physical control of the movement of a vehicle. In accordance with the rules of statutory construction, they can't all mean the same thing. Each one of them has to have a separate meaning. And I went to work for PennDOT in 2000. I research and write briefs, primarily for Commonwealth Court, occasionally for this esteemed court as well. I write at least 20 chemical test refusal briefs a year. Over 23 years, that's over 400 of them. This is the first time I have ever seen a police officer credibly, candidly testify, I did not believe the person was drunk and drove the vehicle after getting drunk. And I give Officer Delnick credit for that. But he also testified that the reason he arrested Mr. Bold for DUI was because he believed he was in actual physical control of the movement of the vehicle, because he was drunk, apparently passed out, in the driver's seat, with the engine running and with the lights on.
And isn't there some danger to just that? We can say, well, you want to sleep it off, you sit in the car and put the heater on, you're not really operating the car, you're not really in control of what happens. But if the car's on, you could, in your drunkenness, I guess, you could bump the gear shift, you could hit the gas pedal, you could do a lot of things that could put someone in danger.
Absolutely, Your Honor. There's no question about it. In this case, and again...
Depends if you're a sound sleeper.
I've been there myself, but that's another story.
Counsel.
Yes, Your Honor.
The question I have is, we seem to be forgetting that the word movement is within the statute. I read your brief, and I didn't find anywhere where there was some evidence of the actual movement of the car. Can you share with me where I must have missed that part in your brief?
Well, Your
Or
Honor,
can you share with me, other than the credible officer's testimony, was that he was drunk and sleeping it off? You have, it appears that you have, removed the word movement and just said he was in actual physical control of the car. But that's not what the statute. So share with us where this movement occurred.
It does not have to, there is no requirement for movement in actual physical control of the movement. It's the control is the operative word, not movement. And I knew the court was going to ask.
But tell me where do you get that? It does not say. We decide what.
Yes, you do.
So I'm asking you, share with us why this court should not follow the strict construction of the statute and have some evidence proffered that that car was moved.
Again, Your Honor, the statute does not require movement. It doesn't say that. It says
actual physical control of the movement of a vehicle.
Okay,
Not actual physical control of a vehicle, the movement, the actual transportation.
Our position, the term actual physical control of the movement of a vehicle has not been clearly defined by any of the appellate courts. And I go through different cases. In one court, actual physical control is the same as operating. In other cases, it's the same as driving. We would submit, the department would submit that actual physical control of the movement of a vehicle means a person who is under the influence of alcohol or controlled substance and starts the engine of a vehicle while in position to be able to cause the vehicle to move. That's where the movement part would come in, is in actual physical control of the movement of the vehicle and therefore is in violation of Section 3802 of the Vehicle Code.
Mr. Edwards, is it a completely different case if the guy comes out of the bar, he's drunk, he's cold, he wants to sleep it off, he goes into his car and turns it on, turns the engine on, but then sleeps in the passenger seat? Is it a completely different case?
That's a tougher question. I thought Your Honor was going to say crawls into the back seat and falls asleep. In that case, again, under the definition we proposed that the court should adopt, in that case, no, there wouldn't be actual physical control, not because of the lack of movement, but because he's not in a position to start the car going anywhere.
But he was. My hypo is he started the car to warm it up and then reclined in the passenger seat.
That would be different than Banner, because again, in Banner, the keys were in the ignition, the engine wasn't on, and Mr. Banner was in the passenger seat. It might have this court might have come up with a different analysis in Banner if, in that situation, Mr. Banner was in the passenger seat, but he's like passed out, engines running. My concern, and I think our concern, would be someone in that condition can very easily move a car by mistake, not intending to. A police officer comes, knocks on the window, tries to wake him up. He's startled. He wakes up. He says, "Well, I need to go somewhere. I've got to."
It's a gas.
Right. He has to put it in gear.
But counsel, but doesn't that defy the fact that the car is in actual movement? So you want to criminalize someone with this potential of actual movement based upon a hypothetical?
No, Your Honor.
The statute says it's a movement. You're saying, well, we have to suppose that possibly that he could, in a knee-jerk reaction, touch the gas and move the vehicle, which, in effect, would trigger the statute. But the individual who got outside Premontes went to sleep in the car, whether it was the front, the passenger, or the back, just fell asleep, and there's no movement. See, it's different. Don't you think, or share with me, Is there a difference between turning the ignition on and defining the turning of the ignition on as operating a vehicle?
Well, in that event, Your Honor, Valentine, we also...
I'm asking you on this particular fact.
Yes.
Because you said you believe that if an individual turned the car on and fell asleep in the back seat, that may not be an actual physical control. I'm asking you, but would that be an operation?
Under Valentine, it might be, Your Honor. We respectfully submit. Each of these cases are very fact-specific.
Well, which one are you relying on?
Both,
Are you? You're not saying he drove.
No.
Okay.
He did not drive.
Are you? And you can't rely on both because they're supposed to mean different things, right? So, is your theory that he was operating the vehicle, or is your theory that he was in the actual physical control of the movement of the vehicle? And I think you have a plausible argument, because even though I'm not moving this lamp, no one would say I'm not in actual physical control of the movement of the lamp. I can make it move or not.
Yes, you can, Your Honor.
But you have to choose which he was doing, because the proof points have to necessarily be different. Was he operating, or was he in actual physical control of the movement of the vehicle? They have to be two different things.
Actual physical control of the movement of
So we shouldn't even talk about operating.
Well, Your Honor, we didn't include Valentine as an alternative for the court to consider.
But what was your theory?
Our theory is that this is actual physical control of the movement of a vehicle.
Okay, so we could end this case by simply saying, no, it's not, and not talk about what all the other things are.
Potentially, yes, Your Honor.
Or alternatively, we could also say he operated it by turning on the ignition, turning the heat on, and not do the physical, the actual physical. We could do either or both.
Our argument is either. Our principal argument, again, is that this is... we have a very smart police officer, an Officer Gelnet, because he knew at that point, as far as he was concerned, Mr. Baldwin was not driving the vehicle, it wasn't moving, he wasn't operating the vehicle. He specifically said, I thought he was in actual control of the vehicle.
Because he had it on and he was behind the wheel.
Exactly.
What about, I'm sorry, Justice, well, then I'll stop. What about the Penn State example that Mr. Spree mentioned about the RVs? I hate to say, pick on Penn State, but the RVs and, the revelry that happens, and the fact that the RVs are oftentimes just running during it, and, the owner has it running, but has no intention of going anywhere.
Then there's no actual physical control as we would define it, because there's nobody in a position to do anything at the point where the engine's running to move it. It's when that person gets in, and that's why I had a hard time with the question about being in the passenger seat. When the vehicle's already running, a person who's in the driver's seat obviously has the ability to move it, whether intentionally or not. When you're drunk, and I will just say when you're drunk, you do things sometimes you don't even know you're doing. A person in the passenger seat has the potential to move it as well. Again, probably by accident, because you're not sitting in the driver's seat, you don't really want it to go anywhere, but you can move it. Again, you have actual physical control of the movement, because you, as Your Honor pointed out with the lamp, you have the ability to move it. It's when someone, our chief counsel, former chief counsel, he asked me a question like that. He said, what about these cars that you have the ability to be inside your living room, and you turn it on, and it's running, and there's nobody in the car? And I thought about that, and I said, yeah, that makes sense. That wouldn't be actual physical control, because there's nobody there who's going to be able to move it until somebody actually gets in the car. When someone is in a position, again, as we would define it, to be able to affect or cause the movement of the vehicle while intoxicated, that's actual physical control of the movement of the vehicle. And the key word, again, is control, not movement.
Counsel, let me ask you your opinion on Banner. You and the police officer obviously did not believe that Banner's holding that there has to be a showing that at some point in time prior to the arrival of the police officer, the vehicle had been driven.
Mm-hmm. Yes,
so what are you asking us to overrule Banner, or
no?
What does Banner mean then? It's limited to its facts?
One of the cases that the court cited was Farner, which is cited in our brief. in which Commonwealth Court, I think, correctly said there's no requirement for movement. So while the opinion of the court addressed that set of facts, Mr. Banner didn't start the engine. He wasn't in the driver's seat. It wasn't going anywhere. Although he left the keys in the ignition, he didn't start it, never started the car. In that case, Farner, which the court did favorably cite, would hold that there's no actual physical control. There obviously is no driving. There's no operation of the vehicle. So Banner would not have to be overruled, probably distinguished.
What does language in Banner mean then, at the very least, and whether there was other evidence that the motorist had driven the vehicle at some point prior to the arrival of the officer?
And that's what this court held in that case.
In Banner?
Yes, Your Honor.
So that's no longer good law?
But the facts don't support the court's holding. The court rejected the argument.
So that's not the holding of Banner?
I'm sorry, Your Honor?
So that's not the holding of Banner?
Well, the court...
That's what they said you looked at.
The court rejected the argument that PennDOT made, which is the vehicle must have been driven because it was found on the side of the road by the trooper. In this case, we're not making that argument. We're focusing on the fact that we have someone with the engine running, the lights on, in the driver's seat, passed out, drunk, who's in a position to move it at any moment and potentially put it in drive. He was in a parking space in a busy parking lot, not far from Andy's. If you've eaten from Andy Brothers, you know there's going to be a lot of people there on a Saturday night.
So it's circumstantial. What's your advice to somebody who's had too much to drink in a bar? Don't go near your car. Certainly don't open the door. Certainly don't turn it on.
Sleep in the driver's seat.
Yeah. No.
Sleep in the back seat.
Everyone has a cell phone. I even have a cell phone. I'm a troglodyte.
Don't get in your car. That's
well,
what you're saying.
I'm saying initially, if you're that drunk, you know, as Mr. Bold did, I should not be driving, but I'm going to try to sleep it off. I'm not going to drive while I know I'm incapable of doing so. You can call your spouse, call a friend, call a cab, call an Uber, call a Lyft. Do something other than put yourself in a position where you have started that car, you pass out, there's no telling what's going to happen while you're passed out, and it could lead to...
So the elderly individual who lives by himself on a welfare check doesn't have the ability to have a friend, a phone, or the access money to buy an Uber. Your position is that that person, I guess, should just, what, walk it off, sit and freeze to death? Really?
Well...
That's what you just said, so share with me,
well,
because I'd like to think of those who are not capable or privileged to have family, friends, and money.
If you're going to go out drinking to excess on a cold night, my recommendation would be put a couple of blankets in the trunk. I have a blanket in my trunk. Now, I don't go out drinking and get drunk, but if you are concerned enough about it, you do something so that you don't have to turn that car on, especially
So
sitting...
for all those who are mentally unstable or insufficient medically treated, who find alcohol as an alternative source, they may not have the foresight. Is the law created to protect a certain class, or is it to protect every Pennsylvanian? Because right now, you've just discriminated against the poor, the intellectually disabled, and those who may not have that access that you've described. What you're saying is that the General Assembly created a statute that said, drink and get near a car, we're going to convict you of driving. When the underlying principle is the ability to drive safely, incapable of safe driving. So I'm somewhat confused as to your logic or your argument.
Well, Your Honor, the question is, what else can you do besides getting in the driver's seat, drunk, passed out, turn the engine on? Who knows what's going to happen after that? One thing is you can make a call to somebody who can come and pick you up. Typically, what I see in these cases is the person gets arrested for DUI. We get involved because there's a chemical test refusal. What always happens is they go to the station, the DUI center, wherever, and they refuse, and then the police call, somebody comes and picks them up.
With all due respect, counsel, your argument is once again premised upon the privilege of having the necessary funding to have a phone to call a friend. What if this person, let's follow your game. The person you're discussing is able to own a phone, but she forgot it. Now she's out there all alone with her car, and it's snowing out, and she knows that she feels that she may not be drunk, but she wants to protect herself because she's a conscientious individual who said, damn, I shouldn't have had that third glass of wine. Let me just sleep it off. Your position is she should be arrested and charged with a DUI offense for being a good citizen, worried about not only herself, others on the road. Is that what you're sharing with us? That's the government's position?
No, Your Honor. We want to protect everyone from someone who could unintentionally drive while under the influence. If that same person gets in the rear seat and leans over the top of the bench and turns on the engine, if the car is parked properly and she falls asleep in the back seat, we're saying we don't have a problem with that. She's not in a position to control the movement of the vehicle because she's in the back seat.
So in this current state of carjacking, I happen to come from Philadelphia. We have people dying all the time. So now you're saying the government advocates not getting arrested for DUI, but being a victim to carjacking.
No, Your Honor.
Well, that's the practicality of the Commonwealth's arguments when we have to determine the statutory definitions.
Counsel, do you see your argument as being a sea change in the law?
Yes, Your Honor.
Okay, that's what I thought.
Yes, absolutely.
I thought you're arguing. I think that your argument would be a sea change.
Yes, it
in
would,
this
Your
area
Honor.
of the law.
As I said, I've probably written 400 briefs. This is the first time I've ever had an officer candidly admit, I arrested this person for DUI because I thought he was intoxicated and in a position to control the vehicle and move it.
Thankfully, his candor allows us to have an opportunity to interpret this challenging statute. Can I just ask this? Do you draw the line for purposes of today's inquiry between the back seat and both front seats, or do you draw it between the driver's seat and all other seats in the car? Do you follow what I'm asking?
Yes, Your Honor. The possibility of moving the vehicle while intoxicated is there when the person's sitting in the driver's seat and also is sitting in the passenger seat with the engine running or turns it on. In other parts of the vehicle, let's say it's got 9 seats, if you turn it on and you're in the back, it's not going to move. If it's going to move, it'll be because of a vehicle defect, not because of anything that you, as a drunken person, caused the vehicle to do.
You're going down an incredible factual rabbit hole, because I can tell you that you cannot easily operate my truck from the passenger seat.
Okay.
It's not an easy thing to do.
I understand.
And I'm not sure a drunk person could do it.
But you could bump a steering wheel, or a gear shift, possibly.
Not on my car.
Throw it into drive.
Not in my car.
We'll have a demonstration.
Okay.
Are you finished?
Yes, I am, Your Honor. Thank you very much.
Well argued and interesting case. Thank you both.
Oh, you're welcome. Thanks, Ed. Yep, we'll see.
This case.
City of Lancaster, Borough of Carlisle, and Borough of Columbia versus the Public Utility Commission. Representing the commission, Mr. Joseph Cardinale Jr. Representing the city, Mr. Michael Peters.
The City of Lancaster, along with the boroughs of Carlisle and Columbia, filed a petition for review in the Commonwealth Court challenging the validity of a Public Utility Commission regulation which addressed whether a natural gas distribution company should install natural gas meters inside or outside of properties located in a historic district. The municipalities contended that the regulation was an unconstitutional delegation of legislative power in violation of Article 2, Section 1 of the Pennsylvania Constitution. The Commonwealth Court granted relief and declared the challenged PUC regulation unconstitutional, finding that the regulation failed to provide adequate standards to govern the gas company's meter placement decision and did not set forth a formal adjudicative process allowing a property owner to appeal the gas company's decision to the PUC. In this appeal, we examine the propriety of that ruling. Good afternoon.
Good afternoon, Chief Justice, Justices of the Supreme Court. May it please the Court, my name is Joe Cardinelli, and I represent the Pennsylvania Public Utility Commission in this matter. The Commission's principal brief and reply brief set forth the Commission's entire argument, but there are 3 points that I would like to discuss with the Court here today. My first point will focus on the purpose of Section 59.18. My second point will focus on the municipality's subdelegation argument and the flaws therein. And finally, my third point will focus on the effects of the Commonwealth Court's decision with regard to the area of field preemption in the utility space. So to my first point, the amendment to Section 59.18 was promulgated after the Commission went through the rulemaking process and determined that inside gas meters contributed to gas meter leaks that ultimately could lead to catastrophic explosions. As such, the amendment in 2014 to Section 59.18 made outside gas meters the rule with limited exceptions for interior placement of gas meters, and in this case, historic district buildings. Section 59.18 was promulgated primarily with safety in mind, but it also took into account historic aesthetic. As I will discuss, Section 59.18 directs NGDCs to consider maintaining indoor gas meter placement if a request for it is made and when the conditions in subsections D2 through 4 of Section 59.18 dictate that it can happen safely. Safety and historic aesthetic are competing interests, and the Commission is tasked with ensuring that NGDCs provide adequate, efficient, safe, and reasonable service and facilities. As such, the Commission is in the position to balance these competing interests when disputes arise. To my second point, there has been no delegation of the Commission's authority in this case. The ultimate review process still rests with the Commission. As discussed in our brief in detail, the decision for meter placement is a managerial decision that is ultimately reviewable by the Commission. However, the municipalities are trying to shoehorn the Commission's regulation at 59.18 into a subdelegation argument by emphasizing the initial duty that the NGDCs have with regard to meter placement. Section 59.18 set forth a thorough standard for making this meter placement decision that governs this initial decision. With regard to inside meter placement, subsections D2 through 4 set out all of the requirements that must be met in order to safely maintain an indoor gas meter, and sections A1 through 12, B1 through 2, and C1 through 4 set out the parameters for consideration of exterior placement. The Commonwealth clearly erred in holding that Section 59.18 granted NGDCs unfettered discretion.
Well, isn't the opposite true? In the absence of 59.18, they had unfettered discretion.
That's true.
There is no statute enacted by the General Assembly that directed the PUC to specifically regulate on its own meter locations.
Correct, Your Honor. Before the 2014 amendment was enacted, we had a simple regulation in place that simply left it to the NGDC's discretion.
You didn't. All you did was confirm it was left to their discretion. It was in the absence of a statute that puts it somewhere else that says the PUC must deserve the NGDC's determined meter location. In the absence of a statute telling them they can't, the General Assembly hasn't prohibited them from making that decision.
That's correct.
What you have done is you have passed a regulation that limits their inherent ability to decide where they can place meters.
That's correct, Your Honor.
So where is the legislative authority that was purportedly delegated improperly to the NGDCs?
And that's what we're arguing, Your Honor, that there hasn't been a delegation of authority.
What's amazing to me is if you read the Commonwealth Court opinion and even your briefs here, nobody really makes that point. Nobody really starts from the premise of Protz in City of Williamsport and the other cases with a General Assembly statute where they've constitutionally exercised their prerogative to create a rule and see where they, in that statute, delegated something without guidance. Nobody started there.
Well, Your Honor,
and you didn't even start there.
No, with Section 1501 of the Public Utility Code, that is where the authority comes to regulate utility facilities. Facility is a gas meter. That constitutes a gas meter.
But it doesn't say regulate location. That's like the statutes in Pennsylvania that say the insurance department shall regulate insurance.
But it's all under the roof of providing reasonable, adequate, efficient, safe service.
Yeah. Put differently, if I can follow up Justice Bronson's question, because I agree that this was obscured even in your brief, is that was not a delegation by the General Assembly of any legislative authority to PUC, as I understand it. There was a rulemaking, there was an administrative delegation.
Yes.
I mean, you're not conceding, or are you, that your commission has been delegated anywhere, any legislative authority, are you?
No, Your Honor. No. This is we cited in our brief that this is a managerial decision. The commission cannot regulate every aspect of utilities, and there has to be some leeway there for them to carry out their daily, day-to-day operations. And since NGDCs are in the position to assess each property on a case-by-case basis, they're in the position to determine what is safe and reasonable initially. Now, if there's any dispute there is always that complaint process before the commission under Section 701 of the Public Utility Code, and whatever that NGDC's meter placement decision is, it has to be reasonable pursuant to Section 1501 and 2205 of the Public Utility Code, and also taking into consideration, or especially taking into consideration, those enumerated parameters set forth in Section 59.18.
Can I just?
Yes.
So, is your point that this review mechanism satisfies the intelligible principle test, or rather that no intelligible principle is even required because there's not been a delegation of discretion in the first place?
The latter, Your Honor. There hasn't been a delegation in the first place because, and if you look at what the regulation was before, this hasn't been amended since 1971. There were only two options. Either the NGDC puts the meter inside, and it has to be away from, it has to be in a ventilated area, or it goes outside, and there we had, in the judgment of the utility, where the meter goes. And in that case, when that was the regulation, the Commission's formal complaint process always stood ready to review that NGDC's decision, and there was never any delegation of the Commission's authority over the NGDC in that matter. And with respect to the cases that the Commonwealth Court relied upon, Protz, Pennsylvanians Against Gambling, Williamsport, and 425 Property Association, all of those cases involved outside authority making a determination with no established standard.
See, and that's where your argument lost me on this issue that Justice Wecht and I have been asking you about. You only go down that road if you started from a principle of delegation of legislative authority. In Protz, it was a legislative enactment that said AMA guidelines from this third-party entity control there. And that took the basic policy decision away from the General Assembly. The General Assembly delegated it improperly to an outside party, standards that can change over time, sight unseen by the General Assembly. City of Williamsport was the same thing.
Yeah.
The City of Williamsport was a statute that authorized local municipalities to pass a construction code, and there, in language toward the end, not the root ruling of the case, was if we would allow a municipality to delegate that delegation from the General Assembly to a third party, it's essentially the same thing snowballing. Start with me from this principle where the alleged General Assembly, you don't have to go down this road that you're going down unless they prove there was a legislative delegation, something where the General Assembly said, we delegate to the PUC, for example, the exclusive power to designate where meters go, and they must set the standards.
And
There's nothing like that.
And, Your Honor, the municipalities and the Commonwealth Court's majority decision kind of shoehorned this into a sub-delegation argument that we have been pushing back against, since that's kind of the framework that this has been pushed into. And I agree with you. The Commission's position is there hasn't been any delegation here.
This is a regulatory event. This is you regulating an industry and putting restrictions on how the industry can operate, not telling the industry, the General Assembly told us to do this, but we're going to delegate to you to do whatever you want to do.
That's true. That's exactly what our position is. But in response to the municipality's sub-delegation argument, that's why we go down that road of why this can't even be sub-delegation if you're going to look at it that way.
Because there's no delegation to begin with.
That's exactly right, Your Honor. And with regard to the review process before the Commission, as we noted in our brief throughout case law, the reasonableness standard is recognized throughout case law as a defined standard of review, which is what any dispute against meter placement would have to stand muster before the Commission. And further, as we noted in our brief, ad hoc decision-making by the NGDC is not possible here because the Commission is capable of developing a body of case law establishing what constitutes reasonable placement of gas meters in historic districts. And finally, to my third and final point, the Commission's recognized field preemption in the utility space will be ignored if the Commonwealth Court's majority opinion is left in place. As I noted earlier, if this Court upholds the Commonwealth Court's majority decision, we revert to the 1971 version of Section 59.18, which simply gave NGDCs the option to position gas meters indoors or outdoors with few enumerated parameters for consideration. However, there was no enumerated exception for indoor meter placement for historic district buildings in the prior version. So we're almost going backwards here if it's left invalidated. The Commonwealth Court, when the meter placement was subject to the NGDC's respective tariffs prior to the 2014 amendment to Section 59.18, you had a patchwork of varying tariffs of where these meters would go. So UGI's territory, they would have their own set of requirements that would have to be approved by the Commission where the meters go. The other gas companies, they would have tariffs in place that would be totally different. What the Commission did with Section 59.18 is make this a uniform application across the Commonwealth so that we didn't have this patchwork of varying tariffs on where meters go. And if the Court recognizes Section 59.18 as improper subdelegation, it will throw into question the Commission's area of preemption that this Court has consistently recognized. While the Commonwealth Court dismissed the municipality's Article 1, Section 27 argument on the historic aesthetic damage, the status of the affected buildings and the local ordinances are still very much at the heart of this case. This Court's majority opinion in PPL versus City of Lancaster from 2019 held that local municipal ordinances cannot stand in the way of the Commission's regulations since the General Assembly directed the Commission to be in charge of regulating utilities. So, Your Honors, if the 2014 amendment to Section 59.18 is left invalidated, the utility space and the field preemption that the PUC has recognized as having will be put in jeopardy. And with that, if Your Honors have any further questions, I'd be happy to answer them.
Any other questions? Mr. Cardinale, may I ask, is this
Yes.
your first time arguing before our court?
This is the second time.
Second time.
First time for the PUC. I was a district attorney, and I argued in 2016.
All right. Well, very nice job. Thank you.
Thank you.
And I'll ask you the same question.
It is my first time,
Well,
yes,
welcome,
Your Honor. Thank you
welcome.
very much. Chief Justice, Justices, Counsel, my name is Mike Peters. I'm an attorney with Eastburn and Gray out of Doylestown. And you started with someone who's sick. You're ending with someone who's sick. But I've been sick for like a month and a half, so don't worry. You're not going to get anything from
Okay,
me.
we're still going to fumigate after you leave.
That's fine. To first respond to the Justice's questions regarding delegation, Section 501 of the Public Utility Code indisputably delegates to the Public Utility Commission the ability to regulate public utilities and all things public utilities.
Of course it does.
So to argue that, sorry, go ahead, Justice.
You said indisputably. I don't know whether you're saying indisputably that is a legislative delegation. In other words, they have delegated administrative authority. You're not here to tell us that our General Assembly has delegated to the Commission legislative authority, are you? Because that would be unconstitutional, wouldn't it?
No, I'm not. It's regulatory authority, of course.
Well, then, if that's the case, where did they get the legislative authority you claim that they delegated here?
I'm not quite sure I'm following. So it's a sub-delegation of legislative
call
authority.
it a sub, call it whatever you want.
But that's how the case is treated, though.
Well, that's how the Commonwealth Court treated it. We're here to talk about that. If you agree with me that the General Assembly could not have delegated legislative authority to this administrative agency, then where did the administrative agency get this legislative authority that you're complaining of here that they allegedly delegated?
You're referring to legislative authority, but I think what has happened here is they've given authority to the PUC to regulate. There's no doubt. That comes from them as the legislature down. The legislature could have created its own regulations. It chose not to. It chose to give that power to the Public Utility Commission. Our position is, in exercising that authority, that power delegated from the General Assembly, they need to do so in a manner that's consistent with their powers.
Let me just try one more time. Okay, so we've established that the General Assembly could not delegate legislative authority to the PUC. It's pretty basic. That's consistent with PROTS, right? They can't do that. It's unconstitutional. Correct?
Understood, sir. Yes.
All right. And yet, your argument, I think, is that notwithstanding that the PUC then turned around and delegated its legislative authority to these gas companies. And what I'm asking you is, where would it have gotten such a legislative authority?
They delegated their regulatory authority, I suppose would be the right way to
See, and that's where you have a problem, because the doctrine of non-delegation of legislative authority is constitutional based in Article 3 of the Pennsylvania Constitution.
You're absolutely right.
So you have to start, as Justice Wecht is prodding you, with an unconstitutional delegation of legislative authority, meaning the legislature has a non-delegable duty to establish the public policy. For example, if the legislature passed a PUC code that says, we are establishing the Public Utility Commission to regulate all public utilities in Pennsylvania, but we're not going to define it. We're going to let UGI, this private entity, define what a public utility is, and that's it, they said. That would arguably an unconstitutional delegation of legislative authority, because the basic policy decision of what entities are to be regulated by this entity has to be made by the General Assembly. You lose traction when you argue about regulatory authority, because there's no constitutional non-delegation of regulative authority. You'd have to cite to me a constitutional provision that prohibits an agency from rather than choosing to set standards specifically about individual things, sets guidelines to allow the regulated entities to make those choices. You understand the difference?
Sir, I do. Yes, and I'm not telling you that I have a case that says that. because I don't. The arguments we made to the Commonwealth Court, again, were based on the delegation from the PUC down. So if this court determines that as a matter of law that is not subdelegation, then my case is cooked, right?
But I guess the problem is if were you maintain that the pre-amended version of 5918 under your theory was an unconstitutional delegation of administrative authority?
No. So we haven't taken that position.
Even though the NDGCs had even more discretion under the prior version than they have under this.
Well, you say that, but you have to recognize that it went from being they could be inside to now NGDCs, you must move them outside. That's what the new regulation says, unless you fit these exceptions. So
right, but you're skipping my premise. The pre-amended version granted the NGDCs more discretion than this one.
Theoretically, I think that is correct.
So
now, in terms, I'm sorry, if I could just make my point, and then, but I'm not disagreeing with you. The PUC decided to create an exemption for historic structures, historic properties, right? That didn't occur under the prior regulation. Having made the decision to do that, which under the delegation doctrine, whether or not you determine it can be applied, they made that policy decision. They then have to set adequate standards. I'm not saying the old regulation was better. When Commonwealth Court asked me if I wanted it to be stricken completely, I said no, honestly, because in many ways, from a safety standpoint, it's better than the old version was. The issue is that under the delegation theory, if they decided to treat historic properties differently, they have to impose adequate standards. And it's our position that they have not.
That's where you lose me. I mean, here they did they had an administrative delegation from the General Assembly, and pursuant to that rulemaking, they did a notice and comment procedure, and so there's that silo. And so there's been no delegation of legislative authority, and therefore there can be no subdelegation because there's been no delegation. What am I missing?
Well, the issue would be then, in that circumstance, that a state regulatory agency could pass on its regulatory power to a private entity, which I don't think is correct.
Well, you can contest those regulations under the regulatory paradigm, but how are you getting that under a non-delegation?
Well, take a look at, to that point, take a look at the case. There is a case, the Center Park case, where they tried to apply Section 5918. And by they, I mean the Public Utility Commission. It was a Public Utility Commission case. It goes on for 80 pages, and they're not able to establish a standard because, frankly, there is no standard in Section 5918. The only standard in those 80 pages is the standard that UGI itself created. So what's going to happen if Section 59 remains as is, gas utilities are simply going to relocate all meters to the outside, or they're going to create their own historic review procedure that doesn't end up being subject to any substantive review. The operative word is quote unquote consider. That's what it says in Section 5918.
Well, suppose the regulation simply said NGDCs shall locate the meters in a safe way. Period.
And it didn't address the historic aspect at all.
Just said,
under my theory, I'd have to say that that's not an issue because the policy decision I'm latching onto is the historic decision.
But I know, but so the problem is you perceive this as the fact that they have imposed, I'm having a hard time articulating it, that
me too.
that somehow they have delegated to the NGDC the ability to choose how to locate these meters.
In the context of historic properties.
In the context of historic properties.
Correct.
But in the absence of this regulation, it was always up to the NGDCs
Correct,
on where
sir.
to locate.
Yes.
But that wasn't some unconstitutional...
Because the PUC had not made a policy decision to treat historic properties
So
differently. That's
your
correct.
concern is that the regulation is ambiguous.
Well, it is ambiguous. Yes, sir. Absolutely, it is.
So
But that's a different form of challenge, right? Than what's been raised here.
I completely agree with you.
And I'll just be frank. Maybe that's a challenge we would have eventually got to, but we were lucky enough or not to get summary relief on this theory.
Did you raise that in the Commonwealth Court? Did you raise a tire jockey claim?
No, not in this challenge. No, we did not. Yeah.
And you didn't participate in the rulemaking process?
This city and these two boroughs did not. Justice, you're correct.
All right, are there any other questions? You want to wrap up?
Sure. Otherwise, we'd rest on our briefs, and I thank you very much for the opportunity to be here today. Thank you.
Thank you. You both did an excellent job.
Thank you.
Mr. Minner?